You're watching BCTV. We're all about Branford. You're watching BCTV, Branford Government Television, a service of Branford Community Television. This program is brought to you in part through the support of the town of Branford.
Good evening. My name is Peter Basserman. I am chairman of Branford's Inland Wetland Commission. I will now open the commission's regular monthly meeting of February 22nd, 2024. It is now 7 o'clock. This evening's meeting will be conducted as a virtual meeting using the Zoom software conferencing platform. It is being held in accordance with Connecticut's Public Act 22-3. Documents referenced during the meeting are available on the town hall's website. The agenda for tonight's meeting was also posted on that site. A few administrative details for tonight's meeting. First, to provide public exposure to these proceedings, Branford Community Television will be recording and broadcasting tonight's meeting. We're thankful for their participation, and the public can view the recording on the appropriate cable TV channel. As participants in this evening's proceeding, please be conscious of positioning your camera so that your face is visible on the recording. Second, to ensure an accurate and complete record of discussion each time a statement or comment is made during tonight's meeting, the party speaking must announce his or her name before articulating any comment. This applies to any party wishing to participate. Those wishing to speak may use the raise your hand feature to indicate such desire. And if staff would help me recognize those raised hands, that would be very helpful. Third, once the meeting has begun, mute your microphone if you are not speaking. This will prevent unwanted feedback from distorting communications. To speak, unmute your microphone. That's not intended to squelch participation, rather provide some order in the communication process. Fourth, all parties wishing to speak need to be recognized by the chair before proceeding. The intent is to have the meeting run smoothly and record the information accurately. The commission wants to hear from all interested parties. Please be respectful with your comments. I'll take a roll from the commission and staff. When I announce your name, please reply with present. Jamie Frederick, Inland Wetland Enforcement Officer.
Present.
Katie Blanchett, Inland Wetland Associate.
Present.
Commissioner Meinson.
Commissioner Meinson, present.
Commissioner Gokowski. Commissioner Gokowski. Commissioner Amrod.
Commissioner Armrod, present.
Commissioner Boda.
Commissioner Boda, present.
Commissioner Papatonis.
Commissioner Papatonis, present.
It's a busy screen here. Did I get everybody? I think I did. Commissioner Gokowski. It doesn't, Jamie, it doesn't show that he's muted.
I'm thinking he might not be able to hear us.
Yeah, no kidding. All right, at the present time, we have Commissioner Basserman present. We have 6 that have indicated that they are present. Hopefully, during the meeting, Commissioner Gokowski can join us, and we'll note that for the
Welcome
record.
to Zoom. Enter your meeting ID followed by pound.
Oh. Okay. Since 6 commissioners are present.
35005. This meeting ID does not accept.
Since 6 commissioners are present, all commissioners are therefore seated and able to vote. Per our regulations, up to 7 commissioners may vote on an issue. Each vote by a commissioner is an independent vote and of equal weight. For a vote of approval, a simple majority is needed. Any changes to the agenda? Can I ask staff if they have any changes to the agenda?
No.
Okay. First up, we have the approval of the minutes of February 8th, 2024, which was a regular meeting for the commission. Is there a motion to approve?
This is Commissioner Boda. I will make a motion to approve the minutes of Thursday, February 8th, 2024.
Commissioner
there a-
Papantonis, second.
Any further discussion on those minutes? All in favor? Aye.
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 Any abstentions? Any denials? Okay. Well, David's there. I'll now open the public hearing for inland wetland 240102 38 Howard Avenue. Is there any commissioner who needs to recuse themselves from this public hearing?
Jamie Frederick, wetland agent. I want to identify that we did receive a recusal from Commissioner Finaro, so she will not be participating in this proceeding or any other proceedings on the agenda pertaining to 3834 Howard Ave.
And she is not present this evening, correct?
Correct.
Okay. In April 2023, notice of violation was issued for 38 Howard Avenue for recent site activity that was unpermitted. On January 9th, 2024, an application was submitted for regulated activity, inland wetland 240102, with a presentation at the commission's January 12th meeting. Pardon me, January 11th meeting. 3 petitions to intervene were subsequently received. At the commission's meeting of January 25th, the public hearing for inland wetland 240102 was scheduled for tonight, 2/22/24. The enforcement notice was also continued to that date. On February 8th, 24, the commission approved 1 petition to intervene. Tonight, we begin discussion on that application. I now wish to make some comments regarding tonight's public hearing. The purpose of the hearing is a fact-finding mission to understand the application for a permit in its entirety. This is the Branford Inland Wetlands and Watercourses Commission. We are governed by Connecticut Statute 22A, our own town regulations, which are drawn from 22A and modeled after a set of regulations issued by the Department of Energy and Environmental Protection. The Commission aims to apply those regulations in a fair and uniform manner across all applications that come before us. Commissioners that are seated for this application are required to be fair and independent, not predisposed to any outcome. The commission must decide the merit of the application from the facts as they appear on the record and from their own personal observations and technical expertise. Permit decisions must be concluded within timeframes specified by Connecticut statutes and our regulations. The commission is not an environmental review board. It does not deal with planning and zoning issues. It is a wetland agency, and so we want to hear about activities that have a direct impact or effect on wetlands or watercourses. We accept applications as they are proposed and either approve or deny them. It is not uncommon for conditions to be included in the permits that are granted. Commission has the responsibility to determine whether the application is consistent with its regulations. It is therefore important that the applicant has a full opportunity to discuss the details of the application. The commission may ask questions during and after the applicant's presentation. After the commission is finished with its questions, I will open the proceedings to the interveners who have filed to be a part of the application review. Following that, members of the public will be invited to speak. Based on the information presented, the public hearing may be closed or continued to a future date. Does any commissioner have additional comments that they want to add to the record at this point?
Yes, Commissioner Gopowski.
Welcome, David.
I don't know what happened to my computer volume, but I'm here. I'm sure most of you are aware that Attorney Ainsworth has suggested that I should recuse myself from this proceedings. For the record, I have no personal or financial interest with any party of this proceedings. I do not believe that any statements I have made evidence of predisposition. I intend to carefully consider all the evidence that's presented this evening and then render a fair and equitable arrangement between all the parties. So at that stage, I am not going to be recusing myself from this meeting.
Let the record indicate that at 7:10, Commissioner Goklowski is present. Does staff have any additional comments?
Jamie Frederick, in the wetland agent. At the last meeting, there were 3 petitions to intervene. One was acted upon and the other 2 were tabled to provide more time for some information to be submitted. Particularly of concern was the verification of the petition. So we have received 2 new petitions for Coughlin and for Diaz, Romero, and Nori. They do have the verification for Diaz, Romero, and Nori. That the concern that was raised was that both parties should be included in the oath. Both parties are identified in the oath statement provided at the end of the document. So I think that it would be reasonable for the commission to accept petitions from Coughlin, which is Exhibit 25, and Diaz, Romero, and Nori, which is Exhibit 36. And if the commission would like, I can screen share them.
This is Commissioner Basserman. Yeah, why don't you close up?
All right, is everyone seeing the petition?
Yes.
So I believe that the content of the facts laid out is substantially the same as previously. The largest difference, I'm going to scroll to right now, is the verification at the end, where it says on the 7th day of February 2024, personally appeared Daniel Coughlin at 39 Brockets Point Road, Connecticut, and made oath to the truth of the matters contained in the foregoing application before me. So that the previous petition did not have that language. And then for the other one, it identifies personally appeared Stephen Diaz Romero and Sophia Nori of 34 Howard Ave, and made oath to the truth of the matters contained in the foregoing application.
This is Commissioner Basserman. Jamie, did we take a vote on each of these, on the one that we approved last time, or was it general consensus?
A vote should be made, and it would be to accept if the commission felt that was appropriate. And there's one for I'm sorry if I say this wrong, Liskio, which was accepted at the last meeting.
Right.
I think you can make a motion to accept both of them as in one motion.
We do that in one vote?
Yeah.
Does any commissioner want to make a motion to accept the 2 petitions that we have before us?
I'll do it. This is Commissioner Papantonis. I move that the petition of Daniel Coughlin of 39 Brockets Point Road and the petition of Sophia Nori and Stephen Diaz Romero, Exhibit 36, that they be allowed to intervene, that their applications be accepted.
Is there a second?
Commissioner Boda, I will
Commissioner
second.
Gopowski, second.
Okay. I think Commissioner Boda grabbed the microphone first. Let me go down to the vote. Commissioner Gopowski,
Yes.
Commissioner Meinson,
Commissioner Meinson, aye.
Commissioner Armrod,
Commissioner Armrod, aye.
Commissioner Boda,
Commissioner Boda, aye.
Commissioner Papantonis,
Commissioner Papantonis, aye.
Commissioner Basserman, aye. Okay. Jamie, do you have any opening remarks, or is it okay for the applicant to start with their presentation?
Jamie Frederick and the wetland agent, I think that takes care of what I wanted to address before the presentation.
All right,
I'll just,
Commissioner Bass, go ahead.
sorry, I'll maybe just identify, because we've got a couple of new commissioners and a lot of members of the public present, that the commission does have 35 days to hold the public hearing. So if the commission determines that they need to continue the public hearing to another meeting, that is a possibility.
All right, for the applicant, it is now your time to make your presentation before the commission.
Thank you, Mr. Chairman. Good evening, Mr. Chairman, members of the commission. I'm attorney Marjorie Shansky, and I represent Kim McCabe and Charles Watts of 38 Howard Avenue. With me here this evening are my clients, Jim Preddy, professional engineer from Criscolo Engineering, LLC in Branford, Matt Davison, soil scientist and wetland biologist from Davison Environmental in Chester, attorney Kevin Walsh, and attorney Sarah Diodabo. Before you this evening is an after-the-fact application to conduct regulated activities in connection with the introduction of the retaining wall, grading, and disturbance of a slope above a watercourse. Since the town's issuance of a notice of violation, soil erosion and sediment controls have been in soil scientists, two on behalf of the applicants, Mr. Davison and Mr. George Logan, and one on behalf of the intervening neighbors, Mr. Russo, have reported no erosion or sedimentation on the vegetated slope leading to the drainage course. And of course, since the mowing of that slope that gave rise to part of the NOV, the vegetation has regrown in last summer during our very robust rainy season. So that the record is clear, the scope of the application does not include that segment of the retaining wall that encroaches by inches on the property of the adjacent neighbor. Your rules require their participation or consent as applicants, and that has been unattainable. In my letter to the commission dated February 15th, I recapped the expert reporting that has previously and currently been provided to the commission to support this application. The list includes 3 reports from Davison Environmental, including the original wetlands delineation letter, the impact analysis and recommendation letter, the recommendation relating to additional plantings to create a bit more of a riparian buffer for the watercourse, and a 3rd letter dated February 15th, in which Matt Davison summarizes the narrow issue before the commission and which he will discuss with you this evening. The list also includes 2 letters from Jim Preddy, the first of which includes or provides a drainage analysis, and the second of which responds to a question about PVC pipe associated the wall that had been asked during the prior proceedings. There is a 3rd letter from Jim Preddy dated February 15th that I did not include in my list because it was completed after I had completed my letter and my list. And that letter specifically responds to the issues raised in the CLA letter of that same date, or February 14th, and which Mr. Preddy will discuss with you this evening. The list includes 2 letters from REMA Ecological Services and 1 letter from professional engineer Michael R. The respective conclusions of the applicant's 2 engineers and 2 soil scientists, wetland biologists with decades of experience is that the patio and retaining wall construction have not adversely affected the wetland resource or the mowing for that fact, the vegetation having reappeared. In my letter to you dated February 15th, I then provide a synopsis of the law governing regulated activity in upland review areas. And I urge the commission to review that carefully at the conclusion of these proceedings. In brief, the sine qua non of review of inland wetland regulation, inland wetland applications is a determination whether the proposed activity will cause an adverse impact to a wetland or watercourse. The conclusion, the intervening conclusion, and the consistent opinion of the soil scientists is that no impact has been experienced. The other important thing about the synopsis of the law that I provide is that activities in upland review areas, which is a description of where these activities have occurred, is that the examination is not to what impact the activity has on the upland review area. It's permissible to have regulated activity in the upland. The question is always, what is the impact on the wetland? In this case, there is none, but I urge you to review the law. In my letter, I also refer to an alternative that we have provided to the agency, which is consistent with section 7.7.I, section 3. And this alternative is predicated on some activity at the Branford Planning and Zoning Commission in January of this year. On January 18th, the Planning and Zoning Commission discussed and ratified its interpretation of section 6.13.c of the Branford zoning regulations, an interpretation that has been in effect since 2015. At the January meeting, the members of the commission agreed that retaining walls 3 feet or less in height are not subject to setbacks, nor are they subject to building permits. In other words, our alternative for your consideration and our discussion is that instead of removing the retaining wall as proposed, except of course for the encroaching area, which is not before us this evening, the applicant will lower the wall, regrade, and Mr. Preddy will discuss this and demonstrate this to you, the area affected by the lowering of the wall. And this will afford substantially less site disturbance in the upland review area than the removal would necessitate. Either way, they will be performed without impact, but it would be much less disturbance to do it by this lowering of the wall. I have appended to my letter of February 15th a copy of the minutes from the Planning and Zoning Commission. With respect to the notice of violation, the April 24th, 2023 notice of violation identifies 3 actions for the recipient to take: to contact the Inland Wetland Office to schedule a site visit, which has been achieved; that erosion controls be installed as needed to prevent any further impact to the watercourse; and number 3, to attend the Inland Wetland and Watercourses Commission. This was on a certain date, but to discuss activities that have occurred and other activities which may be proposed, and resolution to the violation, and that the commission may require an after-the-fact application or restoration plan. We have provided an after-the-fact application. Mr. Davison has provided a restoration plan or a planting plan down by the watercourse. So I would respectfully suggest that the activities requested in the NOV have been undertaken. Finally, I will say before I turn the conversation over to Mr. Preddy, followed by Mr. Davison, that with respect to the 2019 petitions, that we do not concede that they have met the standard articulated in Nazardo. They do not allege specific impact or the reasonable likelihood of unreasonable pollution to the matters within this commission's jurisdiction in the level of detail required under that case. But we leave the petitioners to their proof because they have the burden on their claim. So with that, I turn this over to Mr. Preddy, unless you have any questions for me at this time. And Mr. Davison will follow him. Thank you.
This is Commissioner Bassman. I think we'd be just as well to have a complete presentation before questions are generated.
Very well.
Good evening, Mr. Chairman and Commissioners. My name is Jim Preddy, Principal of Criscolo Engineering here at 420 East Main Street in Branford. I'm a professional engineer and land surveyor licensed in the state of Connecticut, also representing the applicants at 38 Howard. Jamie, can I share my screen?
I'm working on it right now, and I just request that anyone that's screen sharing share documents that have been submitted, so that way we can reference them at a later date as well. All right. Should be good.
Hopefully all can see that. This is the property at 38 Howard Avenue. It's approximately 6,000 square feet in total along the east side of Howard Avenue. The house is here at roughly the front half of the property, existing driveway along the side. This is the patio area and the retaining wall area that has been part of this application. And then this is the slope that goes down to the water course at the bottom of the hill. And this was the area that had been removed the vegetation and trash and debris that was under the vegetation. And that has grown back in last year, as Marjorie had indicated. As she said that on April 24th, the NOV was issued. On April 28th, the silt fence was installed along the bottom of the slope as suggested in that. And since then, the site has been stable and I've not been aware of any evidence of erosion since. In speaking about the retaining wall, in reviewing the standard details for the retaining wall product used and speaking with the contractor, the retaining wall was constructed using typical methods and techniques for this type of wall. A leveling course, stack blocks with shear pins or shear plugs, crushed stone and geotextile fabric behind the blocks, and geocrid reinforcement, which is typically used for walls taller than 3 to 4 feet. Most manufacturers of this type of wall have generally the same details with some variations. In this case, the leveling course was poured concrete formed right onto the existing ledge. Geogrids were used between layers and can be seen protruding from the face of the wall where they were not cut off flush. To further reinforce the wall and prevent water from undermining the lowest course, additional reinforced concrete was poured against the back of the bottom of the wall, as can be seen in this photo here. This is the retaining wall along the 34 Howard side, and you can see that there's some poured concrete here up against the back of the wall. This picture is from the 34 Howard Avenue side, and you could just make out in between layers here part of the geogrid that was not cut off flush and is actually sticking out through the wall a little bit. The fill behind the wall is made up of a combination of the existing on-site soils and clean stone materials purchased from Tilcon. Prior to the installation of the patio and the retaining wall, there was an existing wood deck against the back of the house, and a yard sloped in 3 directions, like a turtleback shape. And here's the back of 38 Howard. Here's the deck, and you can kind of see that this is shaped to slope in multiple directions. This is a picture looking toward Howard Avenue along that property line between 34 and 38, and you can see partially the existing deck that was there and how the good portion of this yard sloped in this direction before any of this activity occurred. This is a plan that we put together using the town aerial GIS information. The contours actually were from before the recent activity and still showed the deck in the photos. As you can see, there was a small portion of this drainage area that you could see in that previous picture that was always heading toward 34 Howard Avenue. The majority of the backyard was heading down toward the bottom of the hill where the water course is. The current conditions with the retaining wall has cut off that small drainage area, and that drainage area is now stored with other area that's behind in the fill behind the retaining wall. So in essence, the drainage area that goes down to this water course is all this together. But what we have here is behind this retaining wall in the fill section that did not exist before, a certain amount of storage in the soil and the stone that's there. The significant drainage divide on this property runs along the back of the house. The driveway from the back of the house slopes toward the road, and so does the runoff from the driveway. The downspouts on the existing house are daylighted. They're not connected to any piping, and they generally run off toward the road or toward the southeast. No other drainage piping is connected to the drainage behind the wall. The PVC pipes that were mentioned before, and that can be seen in some of the pictures protruding through the wall, are merely weep drains in the stone to prevent hydrostatic pressure from building up in the event that the fill section is completely saturated.
Moretti, excuse me for interrupting. The fill section in the bottom left-hand corner of the red rectangular area, you had shown the water draining toward 34 previous to, you don't have to switch that image. No, you could stay where you were.
This,
That right there.
yes.
Oh, excuse me. When you said that the fill went in, do you also just say that instead of running off, that the water is currently infiltrating?
What I'm saying is that the creation of the wall and the fill section that raised this area here has now created an opportunity for storage that didn't exist before. There's a lot of exposed ledge. There's very little soil on the ledge, and the fact that it was filled up a couple of feet actually provides a certain amount of storage to this backyard that was never there prior.
As in it's the water is being retained, yes, within that space?
Yes.
And then flowing down further down the property toward the other arrow, or continuing toward 34?
No, it would because of the concrete that I showed you that was poured behind the bottom of the wall. Any of the water that when this section does get finally saturated, any of the water that migrates to the bottom to the ledge would now run along the back of the wall and head this direction. Although I will tell you that this fill section, it doesn't sound like it's a lot, but I've been there a couple times when it's raining pretty good, and I've yet to see anything bleeding out of the weep holes or even through the the layers of the block, which is common on this type of construction.
Thank you.
So the newer block patio behind the house here was constructed, or the newer patio was
In the wetland agent, sorry to interrupt. We have a commissioner with a hand raised.
okay.
This is Commissioner Bassman. Who's got the hand raised?
Goklowski.
Can you hear me?
With an echo.
Are you still on the phone?
I am now. Jim, the retaining wall, did you put the materials behind that wall?
This was Jim Preddy again. This was in this state when I was hired. We actually were hired initially to stake out the property line on this side because there wasn't any evidence of markers, and you could see the odd shape of this. So we were asked to stake out the property line, and then the NOV kind of happened around that same time. So we were asked to assist with the application.
Okay, so you can't say for sure what material is actually behind that wall.
Only from photographs from the contractor and in speaking with the contractor, and actually I think part of the record is a receipt from the stone materials from Tilcon.
Thank you.
Okay. So the newer patio area behind the house was constructed with block pavers. The area is relatively flat as compared to the prior condition. The pavers were installed with stone dust swept into the spaces between the block. This makes the patio at least partially pervious and not totally impervious. Also, the top of the retaining wall along the property line extends above the patio like a parapet wall, acting as a curb to keep any runoff from discharging over the wall in that direction. And this is the property line along 34 Howard. And you can see that water would be directed down along this, I thought I had two pictures. Oh, here it is. Down along in this direction toward the rear where the work was halted, but the plan was always that between the edge of the patio and the back of the wall, there's supposed to be plantings here. They have not yet been put in. Some weedy vegetation has grown up, but again, there has not been any evidence of water running over the wall that I've seen anytime I've been there. The combination of reducing the slope, providing a curb, installing pervious pavers, and retaining a fill section that did not previously exist has reduced the runoff towards 34 Howard and provided a volume of stormwater storage that did not previously exist. We have provided stormwater calculations demonstrating the capture of the water quality volume in accordance with Inland Wetland Regulation 7.6A, assuming that the new pavers were totally impervious as a worst-case scenario. I explain this because there have been allegations by the neighbors that the work conducted on 38 Howard has somehow contributed to flooding in the basement of 34 Howard. I've demonstrated that the runoff from 38 Howard has, if anything, been reduced in the direction of 34 Howard. In addition, I'd like to show you a video from this video is from last July, I believe. This is the front of 34 Howard, and you can see, because the lack of gutter at the time, that the water running off the roof and because of the grading in the front yard was collecting all up against the foundation wall. What you can't see here yet, and you'll see at some point, is that underneath this AC pad, there's a PVC pipe or a pipe that allows the water that was collecting at the front of the house to run down underneath the AC pad and along the foundation close to the property line. In addition, there were claims that recently a contractor for 38 Howard had removed topsoil vegetation from the area between the wall and the foundation of 34 Howard, which is false. On November 1st, 23, the owners of 34 Howard had workers remove every bit of remaining soil in that area and left the bald ledge exposed. The ledge can clearly now be seen sloping toward the foundation as it always has. And I will go, sorry for the back and forth, but can't do. This is the other video. And you could just make out the pipe there that goes under the AC pad, and you can also see that at some point in the past, probably a previous owner had tried to grout the joint between the foundation and the ledge with, looks like, very little success because there's many cracks in it, but that's clearly old. That's been there for some time. And this is a picture of the workers that were working there that day. We submitted a plan with the application, as Marjorie had indicated, proposed to lower the wall and move it away, equally distanced to the height, away from the property line, where we can, where it's not encroaching. But and at that point, it would be, once we've lowered the height of the wall and regraded behind the wall, as I've indicated, the wall would be no more than 3 feet in any location high. Also, in this plan, we proposed to cut back the patio pavers from where they were before to provide a little more lawn area, a little more landscape area. This plan also happens to indicate the location of a small prefabricated shed, less than 80 square feet. Although zoning regulations would allow a shed of less than 200 square feet to be located as close as 5 feet from the property, we placed the proposed shed within the required building setback line, which is this very narrow dash line area here. We have indicated the shrubs to be planted along the watercourse as recommended by Matt Davison. We have also included a seed mix to be placed on any bare soils that still may exist on the slope, although the vegetation seems to have filled back in completely on its own. In light of the recent ruling in January that Marjorie alluded to, we also submit the alternate plan, which was actually the plan that we had submitted originally with the previous application, leaving the wall in place and just removing enough block to get it down to less than 3 feet high and still regrading behind the wall and still removing some of the patio area to increase the lawn and landscaping space. And the other advantage of this is that by not moving the wall, we don't create this very narrow space between the property line and the wall that the owners of 34 Howard would be hard pressed to maintain at that point without crossing 34 Howard. With that, I'm going to turn it over to Matt Davison to speak about the watercourse.
This is Commissioner Basserman. Before you turn it over to Matt, are you saying that the application that we received also now has an alternative plan?
Yes, that's one of the exhibits, one of the last exhibits. And the alternative plan is actually the plan that you saw with the application that was submitted back last summer.
Okay. With the height reduction on the wall included in that earlier plan?
Yes, actually both plans have a height reduction in the wall to conform with zoning. So regardless of if we move it or don't, our intention is to lower the wall to conform to zoning regulations.
And as a follow-up question, does that mean that then whatever the foundation block is, the block that's closest to the ground, or I don't know, was there anything poured before the wall was put in?
Yes, and in fact, Jim Preddy again, in fact, in the picture that I showed from this side, you could see there was a concrete leveling course poured here. So leaving the wall in place would have the also benefit of not needing to chip that out. We could leave that concrete in place.
Thank you.
Matt, it's all yours.
Thanks, Jim. For the record, Matt Davison with Davison Environmental. I reside in Guilford, Connecticut. I'm a professional soil scientist, professional wetland scientist. I'm a certified professional in erosion and sediment control, and I'm a Connecticut certified forester. And I've been working in Connecticut as a natural resource consultant for about 25 years now. I submitted for the record a summary letter. It was dated February 15th, which I believe the Commission has, and I wanted to try to keep it simple and address the wetland related issues pertaining to this application. And I start by discussing the stream channel itself and the condition of the stream. I think it's important to understand that the quality of the stream channel is the highest on the McCabe property. On the McCabe property, the stream is daylighted, and on the banks of the McCabe property, there's dense vegetation, and it's native vegetation. It's primarily jewelweed. And we are also proposing additional plantings, tall shrubs, which would provide additional shading to the watercourse. Conversely, the opposite bank of the watercourse, and you can see this in my wetland report from August, and it would be photo 1. There's a good depiction. I don't know, Jim, if you're able to screen share that. Sorry to put that on you while I'm talking.
Which report was it?
It's the wetland report from August, and it would be photo 1 is a good visual representation of the stream channel looking north. The file should say wetland delineation report but conversely, the opposite bank, the east bank of the stream across from the caves, is lawn up to the edge of the watercourse, and there are 2 pipes visibly discharging directly into the watercourse. Those pipes are of unknown origin, although I would anticipate there's some type of footing drain, but they're discharging directly into the watercourse on the opposite side of the watercourse. And then to the north, along the northern property boundary, from there to Rustic Road, the watercourse is piped. And the piped watercourse has certainly adversely impacted that watercourse. There's a good representation. So the left-hand side is the McCabe property. The right-hand side is the adjoining neighbor to the east, and you can see the pipe outlet at the top of the photo. That pipe is most certainly adversely impacting the watercourse. Piped watercourses, provide no biological benefit, no wildlife benefits, and it also does not provide the benefits of pollutant attenuation that you would get in a natural stream channel. What was interesting is I was provided with a survey from 1988, which I included in the record, which actually has a description of how that watercourse, how the pipe originated. And apparently the property owners who own those properties filled their yards and piped the watercourse at the time. And there's a note on the survey which states that there's no drainage easement here. It essentially says that the property owners filled the watercourse and piped it. I would also point out, as I've submitted in previous letters, that pipe originates at Rustic Road, which it appears that 2 catch basins discharge to that pipe. So you're discharging untreated stormwater from Rustic Road to this watercourse currently. I would also wanted to point out here that if you tried to permit that pipe now, you wouldn't be able to permit that through the Army Corps of Engineers. In the general permit, they allow for piping of watercourses for driveway and road crossings, but they don't allow for it just for filling of yards. And certainly the characteristics of that pipe do not meet any Army Corps stream crossing best management practices or DEEP's guidelines for fisheries. It's a non-compliant pipe. I wanted to also state, as I show in my letter, 3 soil scientists collectively with conservatively over 60 years of experience have reviewed this activity. And I don't think anyone has claimed that there is an impact to the watercourse. And all 3 soil scientists claim that there's no visible erosion on the slope. And I think that's a significant point, because I think if you want to create a nexus to potential wetland effects associated with this patio, for me, it's got to be associated with erosion or stormwater runoff from the patio. Given that 2023 was an extremely wet year, that a portion of the year that slope was more exposed than it is now, I submitted rainfall data as part of my letter that showed that we had 130% of normal rainfall last year. There's been no slope erosion. And I think that makes a lot of sense when you consider Mr. Preddy's testimony previously that the wall detains more than a 100-year storm event. So it also treats the water quality volume. So for me, I have no concerns about wetland impacts related to stormwater. There are currently no wetland impacts to the stream or no impacts to the stream related to the patio installation. And there's been no erosion since this work was done on the slope, despite the fact that we had an extremely wet year. For me, I think this one is, and I got to be honest, I just don't see any potential impacts here, and I don't see any impacts that have occurred. I think if you add, in addition to this, the shrub plantings that we're proposing along the watercourse edge, what you're going to have here is the highest quality segment of watercourse existing on the McCabe property. And I think if there's any meaningful efforts that the neighbors would like to embark on to improve the watercourse, certainly daylighting that pipe section would be where I would start. And that's about all I have for my testimony.
Mr. Commissioner Basserman. Mr. Davison, you mentioned other soil scientists that are in agreement. Does your report name them?
Well, George Logan from REMA Ecological Services submitted a letter to the record, essentially stating that there has been no impacts. I think he also had some planting recommendations, but he was at the site and he agrees with our findings. And then Bob Russo from CLA has just recently submitted a letter to the record. And in one of his bullet points right at the start of the letter, he acknowledges that he saw no evidence of erosion on the slope.
Thank you. Any other presentations, Commissioner Basserman, any other presentations from the applicant side?
This is Marjorie Shansky. No, thank you, Mr. Chairman. We are poised for rebuttal.
Before rebuttal, maybe we've got some questions from the commission regarding the application that has just been presented. I know, I guess I have one. Do we know how much fill was put in that area, Mr. Preddy? You mentioned, the retention aspect, and was it just, screen fill, or was there also small stones in that fill as well?
Okay, Jim Preddy again. I think in one of my letters I estimate a quantity of fill, but regardless of to your question, the fill is comprised of the soil whatever soil was there on top of the ledge and the stone materials that the contractor brought in to fill, to level out for the patio. And I'll say there was a I don't want to call it a receipt, or some sort of an invoice from Tilcon that indicated the amount and the type of materials that were purchased for this project.
And as a follow-up, how did we determine that it would handle more than a 100-year storm?
using standard drainage methods. I took the drainage area, I calculated what the runoff would be if it was all impervious, and not partially pervious. Basically, it's a very small amount of water because it's a very small area. The area behind the wall, between the house and the wall, is less than 1,000 square feet. So there really isn't very much runoff generated.
Mr. This is Attorney Shansky. It's the Criscolo Engineering letter dated July 28th, 2023 is the drainage analysis with the calculations.
Thank you.
Jamie Frederick and the wetland agent. Commissioner Goklowski has his hand raised again.
Commissioner Gokowski? Yep, unmute. There you go.
There we go. Can you hear me now?
We hear you on too many places.
Grab that phone again.
Okay, let me do one thing here. The phone's off.
I think you have to unmute him, Jamie.
Okay, unmute David.
I think he's on two different devices. One minute.
He is. I see him down the bottom here.
I gotta find him. Oh gosh.
How's that?
You're good.
Much better.
Okay. Something's been bothering me through this whole process since this has come before the commission last year. And the biggest concern that I have is, why did these property owners undertake such a project without even checking with the town, without even going to the Inland Wetlands Commission? They know they're within 100-foot purview. I mean, it's very disheartening that we wouldn't have the situation that we wouldn't be sitting here right now arguing, fighting over this issue. I personally have a problem with asking for forgiveness after the fact. And so my question to the property owners, why didn't you go to the town and apply for the permits that were necessary?
This is Attorney Marjorie Shansky.
Attorney Shansky, I would like your clients to answer that question since they are the property owners and they're more equipped to answer that question than you are. Because they're asking us to make a very important decision here this evening, and I would like to hear from them.
Mr. Commissioner, respectfully, there's nothing intrinsic about knowing how an upland review area, a non-wetland area, a previously developed area, and its permit requirements. I agree, obviously, that in all cases, permits should be obtained when they're supposed to be obtained. And we are here respectfully after the fact with the good news that notwithstanding the omission of a prior permit, that there's no adverse impact. And that is, to me, perhaps most germane. We apologize. We are here to correct after the fact the omission. This is not the first applicant who has sought an after the fact permit. And in the fullness of time, the fact that there's no adverse impact, that we're not talking about some clear cutting of a forest, the issue here is wetland impact or not. And the notion of redemption has to be part of the regulatory array.
Attorney Shansky, with all due respect, we do not know what the impact is through Mr. Criscolo's own admission. He cannot say for sure what materials are behind that wall. And as me personally, if I saw that type of construction going on with all the neighbors that have gotten involved in signed petitions and intervened on the whole thing, a simple phone call to the town hall would have solved this problem a long time ago. And, it's very disheartening as a commission that we've had to waste so much time on this particular issue. And that's why I want to hear from the property owners themselves. And I think we should be entitled to that. And with all due respect, I'm not trying to be a hard guy or anything like that. But, I've lived in this town a very long time. And, I've never asked for forgiveness. I've always asked for permission first.
This is Attorney Shansky. The material is reflected on the Tilcon receipt and the site materials. That is the information provided. And from the prior photographs or the pre-construction photographs, the alteration is not so dramatic as to not be reasonably reflected in that description.
On the same token, Attorney Shansky, building a wall on a ledge that I don't know if it'll stay intact or not, because I'm not sure what's behind that retaining wall that's sitting on top of the ledge. I've walked the property when we had the privilege of walking it. And I'm not just blaming your property, your clients for anything, but it's really kind of a catch-22 situation. And I'm not comfortable approving an application after the fact, especially when a retaining wall that size has been constructed, and I see it's tilting through the pictures. It's sloped and kind of wavy on the pictures on one area where the water is sloping down. So I personally have a problem with it, and that's why I can't clear conscience, move along with this.
Well,
can I just interrupt for a moment? This is Commissioner Boda. I wonder if, now we're going to hear also from the folks at 34 and just
okay.
As a longtime commissioner, I would just also remind that we I don't know that the chair, and maybe this would be an appropriate time to put our CVs onto the record of what our personal backgrounds are. And also that just note that when there is expertise, if we lack that particular expertise, so I cannot supplant my judgment over an engineer. If an engineer says this is the calculation, this is how it works. If there are two engineers and they disagree, we certainly have then the opportunity to weigh that evidence and make a determination on it. But we cannot supplant our own knowledge over someone who has particular expertise unless we also have that expertise. So I would just be mindful that we have additional folks to hear from. I'm curious what they have to say, and I want to make sure that we're, as a commission, staying in our legal lanes, as we do have, 6 attorneys sitting here. So I think, let's hear from everybody, and then we can make some judgments based on all of the evidence that's in front of us. And then if we do have personal expertise, we can speak to those areas.
Yeah, this is Commissioner Basserman. I think, as I said in the opening kind of remarks, that this is a fact-finding mission and we have to deal with what's on the record. So the extent that 34 Howard or any of the interveners provide evidence that is contrary to what we just heard, then the commission will consider that in its proper context. But it's a little bit premature, I think, right now to start making any kind of judgments when we've only heard a portion of what we're going to hear tonight.
Jamie Frederick. in the wetland agent, I just want to mention real quick that the commissioner credentials have been added to the record and distributed to all parties, and that the commission should be keeping an open mind, listening to all of the testimony. Shouldn't be making any decisions based off of particular fact or instance. It should be the whole file. And as frustrating as after the fact applications can be, asking for permission after the fact in and of itself is not a reason to not grant a permit. So I think that touches base on the highlights of what I wanted to say. I see that Commissioner Papatonis had her hand raised, and then Attorney Shansky raised her hand as well.
Yes, Commissioner Papantonis, I have a question about the application, because I did notice the applications to clear and grade, and Phil wasn't checked off, but what Mr. Preddy said, and in the July 28th, 2023 letter, there's reference to Phil. So I'm just asking, is that part of the application or not? I'm not sure.
Jim Preddy again, I believe that the patio and the retaining wall were mentioned in the application, and that the fill is part of that construction.
Jamie Frederick in the wetland agent, just for clarification, what I think Commissioner Papatone is referring to is on the application form, and this is common, I think. So it says regulated activities: clearing, grading, filling, excavation, construction, drainage. I mean, theoretically, I would think filling, possibly excavation, construction, and drainage. I mean,
Commissioner Papantonis, that's exactly what I was referring to.
So. So I guess would the applicant like to affirm or refute that for clarification?
I guess I guess that I considered the grading behind the wall, which included the filling, to be part of the grading.
Jamie,
and not a separate activity.
Yeah, I think that is a common assumption. I mean, you can't really have grading without filling or excavation. You'd have to have at least one of those going on.
Commissioner Basserman, and the subsequent information that was provided in the various letters clearly talk about the filling. So even though the box wasn't checked, the application didn't deal with it.
Chairman, would you like to hear from Attorney Shansky now?
Yes. Nobody else has the hand. No. Attorney Shansky, please.
Thank you, Mr. Chairman. I simply wanted to complete the answer I was giving, or the conversation I was having before everybody else joined in. And I'm going to anticipate that comment by saying that I'm not sure that the application wasn't responsive to the scope of the NOV. I'm not exactly sure because I'm having difficulty putting my hands on my voluminous file, but I think there's some coherence between those two. But yes, the filling is a function of the retaining wall. But what I wanted to say was that I certainly would not propound any position relating to engineering, as I am not an engineer. I will say that a 3-foot or less retaining wall, which has been offered to restore this wall to, is exempt from building permit requirements. So and I would also note that the perseveration on the retaining wall in the upland review area, absent with some adverse impact to the wetland, needs to be measured and weighed in this conversation as well. So thank you, Mr. Chairman.
This is Commissioner Basserman. I guess, follow-up question for, Mr. Preddy. If we merely reduce the wall to the 3 foot or less height, and we're not changing the, course of the wall, then we still have a portion of the wall that would remain on 34? That's a question.
Yes, but that would have to be dealt with at another forum, the way I understand it. Because that portion that encroaches, there needs to be permission from both sides, and that's not part of this currently.
Let me understand you. So you're proposing in this application a reduction in height, the wall remaining in its current, if you will, configuration on the ground. Is it presuming that you have permission from 34 to do that?
Either way, the section of the wall that's too high is not the section of the wall that's encroaching. The section of the wall that encroaching happens to already all be less than 3 feet high.
Gotcha. Thank you.
Jamie Frederick and the wetland agent, we have a hand raised. I think, are you a member of the public?
I am a member of the public.
So we'll be taking public comment a little bit later in the meeting. So when the chairman asks for public comment, you can raise your hand and be heard at that time.
Okay.
Thank you. Any other questions from the commission at this point? All right, why don't we move along to, I guess, the interveners. And who wants to raise issue on tonight's meeting from the intervener side? I see a real hand raised from, let's see, is that Mr. Coughlin?
Mr. Coughlin. Yes, Mr. Coughlin here.
Go ahead.
For the record, Dan Coughlin. I reside at 39 Brockett's Point Road. Good evening, everybody. Let me just go back to let me start at the beginning here. I was hired by Sophie and Steve to build 34. They were living in a house. They did some work on it. They wanted to build a new house. The reason I'm going through this is we'll get to my point of what the damage is. When we got hired an architect. Architect came, drew a set of plans. Upon inspection, I said, listen, we got to look. We were trying to reuse the existing foundation because of the nonconformance of the house on the lot being so close to the property lines that we didn't want to disturb anything. When I looked at the existing foundation, it was, it was a 60-year-old foundation and footing. I told them, I advised them to get a structural engineer and to have him look at it and approve it before we built a house on it, which they did. We proceeded to build the house. Eventually, a CO was issued, and they moved in. At some time after that, the retaining wall was built on the adjoining property. Within a certain period of time, they called me up to come look at some damage and water they were getting in their basement. Upon inspection, I found the whole footing was undermining. I said, listen, we got to get a structural engineer here. We got to figure out what's going on. Brought in a structural engineer. He confirmed my issues. He said, if this keeps going, this house could collapse. So at that point in time, I did some structural reinforcing just to make sure the house was not going to keep eroding. There was a concrete footing in the basement. There was dirt under it, and the dirt was undermined.
Excuse me, this is Commissioner Basserman. Can you give us an approximate time frame?
Time frame of
when you had the structural engineer make that assessment?
Sophie, I don't know if they submitted all that, but they have the documentation for when the engineer went there. I didn't hire the engineer. The owners hired the engineer. They could probably supply you with all that when they get on. With that said, there's a couple of facts here. That foundation's been there for 60 years. It never had water problem like this when the wall was constructed, thus the water problem. And when you get into, I'm not an engineer, and I've been around enough to see what's done. When they constructed the wall, and there's been talk about pervious and impervious and the pavers, and we all know that, they take water. Water goes in. The construction of the wall on the property line of the owners at 34, this topo to the town mapping and what was submitted clearly shows the water heads that way. The water goes over to there, and how they constructed, the biggest problem is nobody knows how they constructed that wall. Nobody knows what's in there for stone. And the purpose of the stone is to collect the water. And I get all the 100-year and all the rain, and it's supposed to collect it. But if it's weeping out that wall, or it's built on ledge and the water's going through the ledge, I don't think anybody can sit here and say we know where the water's going. And I'm not here to say I know where the water's going. I know water's going into their basement. I don't know how. But if we don't know how that's built and we don't get rid of that water, then it's going to go somewhere. It doesn't stay in the stone forever. The stone collects the water. The water has to go somewhere. If it's not going out, it's going sideways, and the weep holes are through the block. That's how it's designed. If that block is not pinned to that ledge, I don't know how much hydronic pressure it needs if it's staying in there, what's going to happen to it. The other thing is, they did show a picture of a couple guys cleaning, and that were guys that worked for me. What we were trying to attain or try to assess is, I advised them to put gutters and leaders on the house because there was a lot of water coming off their house, which they did. And then I was trying to assess groundwater versus water that was potentially getting into the ledge, because that ledge, their wall and the foundation for 34 sit on the same piece of ledge. It's the same piece of ledge. So one thing affects the other. They did do a good job and get the gutters and leaders away from the house. And I was just trying to patch some stuff at the foundation, which they clearly showed the picture of, which the engineer showed. I was just trying to get the water so I could see what could run off and see what was coming down in and through. I'm trying to determine how the water's getting into the basement. With that said, we did patch from the house to the existing ledge. Some of the water did slow, but we're still getting water into the basement. The last thing is, there's got to be some repairs made. And because I'm on the same ledge, and my issue is, how can I repair the foundation with jackhammers and break up that rock, that ledge, and repair it when it's on the same ledge that goes under the existing wall that they're going to put in place? The job should be coordinated together. If they figure out a way how to put the wall in and drain the water out, we still got to address the fact that it should be coordinated. We should put it together where we know where the water's going, and I can repair the footing and the foundation together concurrently with the wall repair, however they're going to do this. But I don't know what else. I haven't seen any drawings on the wall. The picture they showed me of the existing block is not really pinned. I don't know if they're going to drill it and pin it, or if that's going to cause more of a problem for water, how the water's getting down and through. I don't know. And how they're going to drain that. I mean, I think it needs more than stone. I think you need pipes to take that water away from their house. or if an engineer has an idea, I'm all ears. But with that being said, I'll hand it over, and that's all I got.
Thank you, Mr. Coughlin.
You're welcome.
Attorney Ainsworth, I see your hand raised.
Thank you, sir. And I'll lower my hand. There we go. So good evening, members of the commission and members of the public who are in attendance. As you know, I'm Attorney Keith Ainsworth. It's my privilege to represent Dr. Nouri and Stephen Diaz Romero. They're the owners next door. You've heard that they live at 34 Howard Avenue. They're also the interveners, or one of the interveners. This has been an enormously frustrating process for me and my clients. But we're here and we're finally getting an opportunity to speak, and we deeply appreciate that, because I think there's a lot that needs to be said that hasn't been said yet. Now, I've been practicing as an environmental attorney. I have offices at 51 Elm Street in New Haven, and I've been practicing for almost 34 years. I have a robust and diverse experience in environmental and land use matters. I have a Bachelor of Science in Biology and Environmental Studies, in addition to English literature. But I've been doing a lot of this kind of work for a very long time, and this has been probably the most frustrating one that I've handled. My clients are law-abiding, tax-paying citizens of Branford who took a dilapidated home and, unlike their neighbors, renovated it legally. They got all the permits. They asked for permission. They didn't ask for forgiveness. They even got a wetlands permit. They abided by it, and they continue to improve that property as reasonable, decent, law-abiding citizens. They were not in residence at the time that the wall was built. They were aware that there was activity that was being built. They assumed it had permits. They assumed that the attorney next door would know enough to get permits. My client's a physician and I think a finance director, but even they knew they needed permits. There is a pending legal action. We've got to state that. It's Nouri versus McCabe, NNH CV 246138-145-S. Civil action pending between these two neighbors over this matter. It's filed in November out of frustration. My clients attended multiple meetings. They went on a site walk. They participated as much as they could in this process to try to understand it. They wanted to solve the problem. We've asked multiple times for meetings between the technical professionals of both parties to resolve the matter. That has been met with silence and some very, very pointed comments when there were comments made. Except for Attorney Perito. I will say Perito just ignored me for a while, but then he finally talked to us for a bit. And then he was fired and replaced by someone who basically treated me like I was a doormat. Now, we've asked for that meeting between the technical professionals to try to work this out, because that's the way it should be, because it doesn't just involve wetlands. It involves zoning issues. It involves flooding issues. It involves trespass issues. Only the Superior Court has the broad authority to deal with those kinds of things. And there is currently scheduled a hearing on March 26th and 27th to actually deal with that issue. It's a temporary injunction hearing at which all of the evidence will be heard for all topics. Both sides will have a full opportunity, represented by counsel and their technical professionals. Now, unlike this agency, the court has that authority to resolve the issues, not just in a limited, narrow way. And I don't fault the commission. You are just an agency that deals with wetlands, and you can't deal with all of the issues. And this is unusual. This is not the kind of thing that you've ever probably seen something like this before. I mean, you've seen after the fact permits, I'm sure, but not quite something this involved. So this is the kind of thing that you're going to see maybe once in a lifetime, or at least once in a certainly in your tenure on the commission. And so what we're going to ask is really that the commission consider refraining from exercising its authority in this instance. That's not meant to be an affront to the sovereignty of the municipality. I was a first selectman of a small town, much like Branford, a town of Haddam, in fact. And I understand that one of the benefits of local agencies and local government is that it's not state and it's not federal. It's much more personalized, and it does have a much more detailed review. And in fact, that's why I think wetlands enforcement is done on the local level, or has been delegated to the local level, because you know the lay of the land. But the best way for this to be resolved is not with a permit before the wetlands agency that they can then now go to the zoning agency, say, hey, we've got an approval. And then the zoning agency then says, well, we feel obligated now to go with the plan that was already approved by wetlands, even though it didn't take into account all of the things. And it makes it very difficult for us to, to manage the legal part of it when the agency's acting on a portion of it. So,
This is Commissioner Bassman, Attorney Ainsworth, we are an agency that just deals with the wetland issues. There are plenty of cases that we look at that are certainly involving planning and zoning. We don't hold off on our decision because there's other activities involved. And we also have timeframes that we have to make a decision now that we have an application in hand. So I'd like to hear what you or your clients have regarding wetland issues at this point.
And I certainly appreciate that. What I'm just suggesting is that the commission's had this matter since April or May, and you've heard testimony that from the applicant, certainly, that the site's stable. The rush to now finish this before the court can hear the matter seems odd and unnecessary. Because if you even take at face value their claim that everything's stable, then there's no need to act on the application simply because they applied for it in January to try to preempt us in court. That was a strategic matter. It's done to undermine our case. And what we're trying to do is resolve it in an orderly fashion. We're asking the commission to refrain from exercising that jurisdiction and to hold this over until that process has been heard, because it may in fact resolve a lot of the problems that are being considered by this agency.
I don't know that. Give this Commissioner Bassman. Do you have any expert testimony that you'd like to provide this evening that takes a different tack than what we've heard from the applicant regarding impact on wetlands and issues associated with the retaining wall?
I do, sir. I have Mr. Rob Sonicson, a civil engineer from Waldo and Associates. I have Robert Russo, who actually has arrived who's a Connecticut soil scientist with CLA Engineers, who will address the wetlands issues. And we have Mr. Raffaele Ascitino, a structural engineer, who is the only structural engineer who you'll hear from, to give testimony before the commission regarding the wall.
Well, why don't we move to having a presentation from them? Excuse me, somebody, would I hear Commissioner Boda say something?
Yeah, if I can just jump in on two things. I think this is Commissioner Boda. I think Attorney Ainsworth, I understand the assertion that you're making, and along with the presentation that we're going to see from Mr. Sonicson, et cetera. If you want to offer us some examples of decisions in which that was a course that the commission, I mean, again, we have to, as mentioned earlier, we have to operate underneath, proceeding decisions or guidance from the state or with our regulations. So this public hearing can be open for 35 days. And I anticipate we could, at that point, ask for an extension if we needed one. But I think I understand the principle that you're asserting. What I would be looking for from you as the attorney is the legal path that would, that as a commission, we could make such a, I guess we could just table it, right? But I think I would be looking for a little bit more guidance from you So along with the presentation again from Mr. Sonicson, if you want to offer that, that would be helpful. And then I also just want to address that there is some comments that have come up in the chat, and I would just like to say this is it's a public hearing, and all comments need to happen here in the video. That's part of the process here. And as the chairman described earlier, we hear first from the applicant, then we hear from the individual interveners, and then we hear from the public. We're here for a very long time, so please be patient as we work through this process in the way that we do consistently with all public hearings. And I will yield.
Thank you, Commissioner Voda.
Sorry, Jamie Frederick, in the wetland agent. Just to clarify, speaking in the chat is kind of the equivalent of speaking over the person that's speaking. So we're just really requesting that everyone wait until their turn to talk, so that way the person that is talking can be heard and focus, the commission can focus on what they're providing as testimony. There will be an opportunity for everyone to speak. Sorry.
And for Mr. Boda, and it doesn't, you don't have to have your camera on to speak, but we're just not engaging in the chat. So when it is that person's turn to speak, you don't have to have your camera on. It's helpful. We do appreciate that, but it's not a requirement. People can call in as well. But we just have an orderly process. I've been on the commission since 2000, and this is the same process that we have used in all of that time. So just hang on tight, please.
Briefly, Inland Wetlands Associate Katie Blanchett. As the chairman stated at the beginning of the meeting, when it is your turn to comment, you need to stick with our purview, which is inland wetlands and watercourses. And because we have a lot of people on, and because we have a lot of people that have something that they would like to say, the commission generally only hears matters related to wetlands and watercourses, and we can't hear planning and zoning, civil rights issues, or anything like that. This is not the forum for that.
This is Commissioner Bassman. Attorney Ainsworth, do you want to yield to Mr. Sonicson?
I thought I might be given further opportunity to make some comments to introduce our position. I don't think I'm going to abuse the privilege, but I think after having attended for so many meetings, it might be time to hear from us. Attorney Shansky was not interrupted. And I think I'd like to just be able to say a few more words. If you'll indulge me, I don't think I'm abusing the privilege here.
As long as we stick to wetland issues, you go right ahead.
Thank you, sir. And I will note that during the course of the testimony given by the applicant, there were some comments about drainage to my client's property and drainage off the property and the property across the stream and the pipe up the street and the drainage basins on the road and things happening on my client's property. So I think I get to comment about those things if they get to. They didn't just stick within the four corners of their property. And they also took some swipes at my clients with regard to the drainage video that individual testifying didn't take and couldn't verify. He didn't even know which month it was taken. And then he's accused my clients of making a false claim that they had removed soil on the property, and then showed a picture of two people who were doing something, but you couldn't tell what. And then said that we made a false claim. So I think I can address that as well. But what I'm getting back to is this commission does have the ability to table or even deny without prejudice to reapply. That would not be the worst thing in the world, to deny the application and then allow for the court process. No court will ever fault you for that. But and there's been a question of in fact, it's on the agenda of whether to issue a cease and desist against my clients to effectuate another portion of the problem that was created by the applicants that is not being addressed tonight. And to simply say, well, that's not before the commission because it's not part of the application, it doesn't seem rational. They created a whole problem and they're not solving the whole problem. And we've been accused of not cooperating. But the thing is, all we've said is we will agree to any process and any permit that solves all of the problems created, not just the problems they want to solve on their property. So we are fully cooperative with that, and we're accused of not being cooperative, but only because they won't talk to us. We've asked for mediation. We've asked for a meeting. We've asked to be included, and all they've done is give us applications and told us to sign on to them. But what I will say is this application does not address the soil that they removed between the house and the wall. It doesn't say anything about that. And that's not just a 4-inch stripe, 25 feet long, and it's actually more than that. We disagree with their survey. But it's actually a 3-foot area that they denuded of soil and exposed the ledge, thereby changing the drainage characteristics in that area. And you'll hear more about that.
I can't wait.
So I will point out that there's some things that you should be aware of and you should be on the lookout for. None of the people who testified before you know what happened behind that wall. We haven't heard from the contractor who built it. I suspect there's a reason for that, but he hasn't shown up here. And only he knows exactly what happened. You don't have cross-section. If they had applied for a permit, there would have been a cross-section. There would have been an engineered diagram. There would have been a representation of how much fill they were bringing in. There would have been a quality of fill that would have been brought in. There would have been compaction reports. There would have been inspections, none of which occurred. None of that information does not exist before this commission. And so we're trying to do things after the fact. And what needs to happen is the wall needs to come down all the way. So I will now introduce Mr. Rob Sonicson to describe from his perspective what this project really represents.
Thank you.
Jamie Frederick in the Wetlands. Sorry to interject. I have seen that Lisa L has had her hand raised. I believe she's another intervener. I just want to identify that you'll be provided an opportunity to talk after the current intervener has finished their presentation.
Mr. Sonicson?
Good evening. My name is Rob Sonicson. I'm a registered professional engineer in the state of Connecticut. I work for Waldo and Associates. Our office is at 89 State Street in Guilford. We were retained by Dr. Nori and Mr. Diaz-Romero, the owners of 34 Howard Avenue, in early May of 2023, shortly after a cease and desist notice from the Branford zoning enforcement officer on April 21st, 2023, and a notice of violation was issued by the Branford Inland Wetlands and Watercourses Agency on April 24th, 2023. The first time I came on the site was in early May. Of interest at that time was the cease and desist notice indicated that the ZEO had discussed the regulatory requirements for wall and patio construction, as well as for a garage construction with the owners of 38 Howard Avenue in October 2022. The cease and desist notice indicated that she thought that it was clear that engineered drawings needed to be prepared and regulatory approvals needed to be gained prior to any of the activity that she discussed with the owners of 38 Howard Avenue. The failure to do either of those things, it's hard for me to see that that was a simple oversight, because they were well aware of the requirements. And that's where the biggest problem for me comes in. And this has come up before, and it's going to come up again. And it's my professional opinion that without the benefit of an engineered design, without any information with regard to how this wall was constructed. I'm most concerned with how the foundation was put together, and there's no information with regard to how that design was done. If you look at the details for the modular walls, they show that there's a stone bed that needs to be installed under them. They really don't go into the details of how you build this kind of wall on ledge. It's much more complex, and I know that there was concrete poured. We don't know if there's any reinforcing in the concrete. We don't know if it's pinned to the ledge. We don't know how it was done. And that's a serious matter because no one has told us. Mr. Preddy has indicated what his understanding was based on conversations with the contractor, but none of the photos that we see show really what went on. The one photo of the wall doesn't give us any information about how that section, which is built on ledge, was actually connected, other than the fact that there was a concrete leveling pad, and we don't know how stable that is. And it's a concern all along the back, the side of the wall between 34 and 38 Howard Avenue, as well as the north side of the wall. That is it's shown on the plan as being built on shallow ledge, and that's up above the wetland and the water course down the steep gradient. So that's the background, and I don't see that there's any way that we're going to be able to really determine with all certainty how that wall was built without getting that kind of information basically in an forensic way. We have to come up with a plan, and the only plan that we can really see is by removing as much of the wall as you need to be able to determine how it was designed, how it was constructed, and whether in fact that construction was safe and sound and meets good engineering practice. One other thing, there's a detail on the existing plan and on the existing alternative plan, and I don't really know if we're talking about that or not. It was only put in the file. We saw it today. I apologize for not having an opportunity to study it in any great detail. But the detail that's on the plan shows, and the modular wall manufacturing companies are adamant about the fact that drainage be provided behind the walls. And we know that there are some weep holes up at the northern end of the wall, but there's no evidence that there's any drainage along the side of the wall between 34 and 38. And going back to what Mr. Preddy said, they poured some concrete along the top of the ledge to keep the water from going through there. But these walls are made, not made to resist hydrostatic pressure on their backside. And in fact, they weep. And there's evidence of the fact that they've been weeping. That wall has been weeping through the wall and cascading down the ledge, and resulting in negative impacts to the residents at 34 Howard Avenue. The February 15th, 2024 letter indicates that crushed stone was placed behind the wall to provide 48 cubic feet of storage volume. And that determination is based on an assertion of the volume of stone placed behind the wall during construction, which we don't know. We just don't know how much was placed other than by conversation. See, I put this much in. I followed what the plans showed. There was no inspection by a qualified professional. And this wall is 2 feet from the foundation wall of the adjacent house. And that doubles the concern with the fact that we don't know how it was actually constructed and whether it was actually constructed properly. There are a couple of other that's the major thrust of my position. And I can't tell you enough about what a concern it is. And it has to do with both the location of the wall on the north side, which is kind of perched above the wetland watercourse and steep slope going downhill, and also the residence that is within 2 feet of the wall on the west side. There are a couple of notes on the plan that I'd like to just mention. Well, first, the other thing that I wanted to bring up, and it was it wasn't mentioned in the presentation, but there was a significant amount of soil removed in order to clear off the ledge to be able to form up the concrete wall or the concrete footing base that we don't really know anything about. But that soil absorbed and conveyed water from wherever it came. And generally it was directing the water down the hill toward the natural course of the flow down to the wetland. By removing that soil, they removed soil from the neighbor's property without telling them or giving them any opportunity to comment on it. And that dramatically changed that small area of conveyance of water. And we have evidence that shows water literally cascading down the ledge. And
Commissioner Bosserman, can you share that evidence this evening?
There's a video. I can't share it with you. I don't believe it's in the file. But I observed it, and the property owners observed it too. So, and if you go out and look at the wall, you can see where the water weeps through the wall, because the wall is made to leak or not retain water behind it, because it doesn't want to have hydrostatic pressure behind the wall. There's no drainage behind the wall that's on the ledge adjacent to 34 Howard Avenue. There are a couple of other things about the plan that there's some notes that say that the retaining wall would be lowered as necessary. And I guess the question is, what is as necessary? I mean, and where exactly is this necessary reduction going to take place? I think that the commission should be able to understand what the extent of that lowering, the extent of the relocation of the wall is going to be. And really, the plans are unfortunately vague. And I think that in this case, much more detail should be given. There's overstrike. It's hard to see where the spot elevations are on the plan. And I think that we need to know what they're going to do, because I don't believe that this commission would want to approve a plan that said, okay, the wall is going to be repaired as necessary, because you need to say this needs to be done to the wall to repair the wall, and not leave it open to a vague as necessary, which would apparently be the responsibility of the applicant, who hasn't done a real great job of documenting anything that they have done heretofore. There's also something, and I don't know, this is sort of for Jamie, but they're going to be planting, they're proposing to plant shrubs, and it says that they're going to put in shrubs that are going to be approved by the wetlands agent. And I guess I'm used to seeing that the type of plants that are going to be planted on a site plan would be specified by the applicant and not just kind of thrown out to be something that the wetlands agent is going to approve. And that would be part of the approval process. I believe that those are that's the main thrust of my presentation. And I want to answer questions, obviously. And I want to give Bob Russo an opportunity to make his comments. And if I need to come back later on, I'd be certainly happy to. But literally, those are the things that I've been looking at. I'm a hydraulics engineer, and I'm very concerned, and I'll just sum it up. I'm concerned with the conveyance of water. Jim Preddy talked about, it's water storing back there. And I think Commissioner Boda said, if I recall, yeah, but the water's not going to stay there all the time. It's going to go somewhere. And that's true. There's another note on the detail of the sheet that says that the capstone is going to be sealed at the back of the patio. And I'm assuming that the reason that note was added is that water currently flows over to the top of the edge of the wall where the capstone is, and seeks its way down between the back of the concrete wall and the patio. That's the normal place that water wants to go. It wants to seek differences in conditions of soil. And so it seeks that kind of thing, and it'll flow down the back. And that's why it's leaking through the face of the wall at that location. If they seal it, then the water is going to be forced to run down to the back. And we really don't know where that water is going to end up going if it gets put in that direction. But that was another note that I noted. So it obviously wasn't sealed in the beginning with the original design, but there was no original design, which I really think is the key to the fact that this is such a conundrum and a difficult case to follow, because if we just cut the wall down to 3 feet, we haven't addressed the real issues of, is the wall stable? Was the wall properly constructed? Was it properly designed? Was a structural engineer involved in detailing the reinforcing steel? And I know that our structural engineer will probably comment on that also. So I'm going to yield the floor, and I really appreciate your listening to my comments.
Yeah. Mr. Sonnickson, could you comment on the possibility of the wall collapsing due to the fact that there may be hydrostatic pressures and a lack of pinning and that sort of thing, and what that might mean for erosion and sedimentation of the brook downhill?
Yeah, well, I think I sort of mentioned that the reason that the modular wall designers are so adamant about complete drainage behind the wall is to remove that hydrostatic pressure, because the walls aren't strong enough to be able to resist hydrostatic pressure behind them. And that's probably the primary cause of failure of these kind of modular walls, not improper drainage. The other, if it's built on a nice bed and properly backfilled and properly drained, They can be very effective and last a long time. But if those things aren't included in the construction, it's a serious potential for buildup of hydrostatic pressure, which could cause movement of the block and eventually lead to a collapse.
And could that result in sedimentation running down slope?
It couldn't help but do that. There would be a significant release of water that would then run down the slope and cause the slope is not stabilized, and even with some conservation mix, there's certainly going to be erosion and sediment that would get deposited in the watercourse.
Thank you, sir. Now I'd like to introduce Bob Russo and ask you to make some comments from your perspective, sir.
Good evening. My name is Bob Russo. I'm a certified soil scientist with CLA Engineers. Our office is at 317 Main Street, Norwich, Connecticut. In addition to having 3 decades or so of experience in this field, I just want to mention that I and my company do support 4 towns and serve as wetlands staff for towns, as well as inspection staff for towns. And that's important because I'm used to reviewing applications for towns, reviewing them for completeness, reviewing them for providing the commission with enough information to make its decisions. Towns like Basra, Guilford, Stonington, and in fact, a couple of years ago, did a review for your commission in the town of Branford on a submission for the industrial park for a site development. So I want to emphasize that I understand, as does the commission, that you rely on materials submitted by professionals to assess whether there's a potential for an impact on a site. Unfortunately, there was construction on the 38, address number 38 site that did not get a permit. So as has been mentioned by Rob Sonicson before me, you don't have the information that you would normally rely on to know about the suitability and stability of that construction. It's good that there's an application before you now, but unfortunately what's out there is a large unknown. You don't know if it's consistent with regulations, with best engineering practices, and so forth. I'd like to just jump for a moment to the visit that I conducted on the site. I did go visit the site on February 9th and conducted a field walk. As Mr. Davison mentioned, I didn't see active sedimentation or erosion on the site. And I think that I can just cut to the chase and say that I think that the observations that Mr. Davison gave you about the condition of the wetland and the functions of the wetland is something that I'm generally in concurrence with. But there are some other issues that I would like to bring up. And I would ask if staff could share the photographs in Exhibit 10C, if Jamie Frederick could possibly bring that up and share it, because there are photographs that I think are part of the record and that illustrate some important points that I mentioned in the letter that I've submitted to the commission. And while that is going on and hopefully showing up, I'll just remind the staff, thank you, let's start with this photograph. And remind the commission, I'm sure you're all familiar with your regulations, but in section 7.6, there's information in 7.6A and 7.6B, and I'm going to quote part of 7.6A that says, all applications shall design to goals or BMTs that will provide protection and where possible enhancement of wetland and watercourse qualities and functions consistent with, and it goes on to cite the Connecticut 2002 and 2004 manuals. Well, the 2004 manual, where we look at management of water quality and cleansing it before it gets to wetlands, behooves the applicant and the designer to look at low impact development. Here we're looking at the backyard of 38 before it was developed. And while we can see some rock there, we predominantly see vegetation. And I would just ask Jamie Frederick to scroll down to show the patio surface after the development. Now, that's the photograph that I'd like to discuss. That's an impervious surface. I know the engineer for the owner characterized it as somewhat pervious. That's really an impervious surface. And in fact, in Matt Davison's letter, he classifies that as an impervious surface. If you look at the differences between those two surfaces, what your regulations are getting at is that the former is much better than the latter. We know from studies that have been conducted by NEMO in Connecticut and elsewhere that when the impervious surface in a watershed gets up beyond about 10 or 12%, you see a degradation in water quality. There are lots of reasons to reduce impervious surfaces. One is to keep warm water that runs off immediately off of a surface like this from getting into a stream and affecting the aquatic life. Another is that impervious surfaces really don't allow infiltration. There's not very much water that's going to get down through the surface that you're looking at there. And I'll ask Jamie if you could scroll back up. We were just looking at a hardscape. Now we're looking at a vegetated landscape that is much more receptive to catching water, slowing it, and cleansing it. So my point here is that the Commission's regulations require that the designer consider minimizing impervious surfaces, and I don't think that's been done here. I think that what was constructed out there did not give consideration to that, and that the additional that the impervious surface that will remain per the current plan that was submitted still increases impervious surface out there and is counter to the Branford inland wetland regulations. I'd just like to quickly summarize a couple of things that Rob Sonicson mentioned. One is that the Commission doesn't have the data on the construction of the wall, the design of it, whether it meets standards or not, and whether or not it's really going to be stable in the long term. And if it does fail, that collapse would lead to wetland impacts. I think that, as Rob said, the only way to really know is to take it apart. So just to summarize, on my site visit, I didn't find that there had been recent impacts. The likelihood of future impacts depends upon the construction of that wall. That's something that's unknown. That's something that should be part of an application to the Commission. I'm very familiar with the process, and all commissions routinely request and rely on designs by professional engineers, designs by professionals in sedimentation and erosion control, and then subsequent inspection of those jobs as they progress. And that didn't happen here. Specifically in sections 7.6A and 7.6B, I think there are places where the application does not meet the standards set forth there. I think that specifically water quality treatment and reduction of impervious surface are not adequately addressed in the current application. I would also just conclude by saying there was soil removal as well between the house at 34 and the wall that was constructed, and that needs to be remedied. Something needs to be restored to that area because there was soil that served a valuable function there. That concludes my remarks, and I'd be happy to answer any questions.
Mr. Russo, this is Commissioner Boda. Earlier, we saw when Mr. Peretti was making his presentation, there was an illustration of the water flow pre and then post with the patio. And there was some conversation about the water being detained he indicated that the patio being somewhat pervious and the water being detained, and then slowly or more slowly, eventually at some point, leadering out through the lower part of the slope and through the wall. So my question to you is, through your comments, are you saying that you disagree with that assertion, or that assertion can't actually be known with the information that we have?
I'm saying I disagree with his assertion that that patio material is pervious. If he has a spec for that particular block that's going in there, I would like to review that data and see it. Having experience in working at CLA Engineers, where we have done stormwater management and pervious pavement design for roadways in various towns, I don't feel that that is properly characterized as pervious. And I also do feel that leaving something in place that we don't know the design for just says we can't really predict how it's going to function.
And then again, Commissioner Boda, as a clarification, so therefore, if it is not pervious, then it could not serve in any form as a detention for water.
Correct. That yes, the water can't get through that surface.
Thank you.
Mr. Russo, would it be standard to see in an application a cross-section of this kind of wall so that some of these questions could be answered?
Yes, in my experience, it would be.
Would it also be usual to see an engineered design for a retaining wall built on a sloping ledge?
Yes, again, in my experience, it would be.
All right. And with regard to the second picture, if Jamie, if you could just roll that up to that second picture. Yes, that one. Mr. Russo, there appears to be you see a scaffolding for working on the house at 34, but underneath there you can see a piece of ledge just behind the fence. Could you comment on how the water would travel from the 38 through that fence past that ledge in this pre-wall condition?
Sure. You would see rainfall falling upon that ledge, and as is evident in the photo, the elevation of the ledge is higher on the left-hand side of the photo. It would travel down toward the right-hand side to house number 34, and then hit the soil that you see there, and up to the capacity of the soil would be absorbed by that soil.
Okay. And then just specifically where you see those, I don't know, I think there's a garbage can in the deck. The water came down from there. Where would you expect water from that location to travel when it hit that ledge? Would it go over that ledge, or would it go down toward the soil area?
Just to be clear, you're talking about garbage cans on the house number 38 property?
Yes, where the mouse is indicating.
So I'd expect that water to travel downward toward the soil area that the scaffolding leg is standing on.
And it wouldn't go over that ledge, it would go around it.
Correct.
And the edge, and where is the edge of the foundation of the house on 34 in this photograph?
In this photograph, there's a yellow cord, I think, that is hung right about on the corner of the foundation.
All right, and that's the end, and that's the end of the foundation, correct?
Yes.
Thank you. I have nothing further for this individual unless the commissioners have more questions for him.
You do have at least one commissioner.
Commissioner Papatonis, you had your hand raised.
Yes, I have a question for Mr. Russo. Did I understand you to say that because there's the surface is impervious, that warms the water and that has an adverse effect or could have an adverse effect on the wetland?
Yes. During the summertime, having solar energy, warming pavement, runoff water that comes directly from there into a stream could have an adverse effect.
Okay, thank you.
And the adverse impact would be thermal?
Yes.
Any other questions from the commission? Attorney Shansky, you have your hand raised.
Thank you, Mr. Chairman. I have a question for Mr. Russo. May I inquire?
Yeah, go ahead.
Mr. Russo, do you know where the property line is on this photograph?
I do not.
Thank you.
Does that conclude the material that you'd like to present this evening, Attorney Ainsworth?
If Mr. Ashatino is here, he is the structural engineer that has been retained by my clients. Mr. Ashatino, are you present? I don't have a list of the folks who are present. Ah, there we go. You'll have to unmute yourself.
There we go.
All right. Can you hear me?
Yes.
All right. My name is Rafael Ascatino. I'm with Ascatino Associates, structural engineers in West Haven, Connecticut. I've been a structural engineer for about 45 years, practiced engineering in the state of Connecticut and many other neighboring states for the last 40 years. I was originally called in to investigate the foundation of 34 prior to their construction, to assess the existing foundation to make sure that it was adequate for the proposed second floor. And we inspected it, we looked at it. It is an old foundation, an old block wall, but in general, it looked a very good, good condition. It was sitting on ledge, and we didn't see any major issue. Recently, I believe in September or October of 2023, we were called by the homeowners of 34 to go back and take another look at that foundation because they were reporting excessive water in their crawl space and some damage to the foundation. We went out there and looked at it and clearly saw that the settlements have taken place at the corner in the near the rear of the house, adjacent to where the tallest section of this retaining wall was. And what was happening is that water is infiltrating through the cracks between the ledge. The problem is everybody talks about ledge and how ledge is impervious. This ledge, as you can see it from all the photographs, has many, many features in it, cracks in it, and very large slots filled with soil. And those are channels that, allow water to flow through. And what's happening is that the water behind that wall, either by the fact that it's the surface on top of the patio is impervious and letting the water run over down the wall and into the basement of 34. And what it's doing is washing out a lot of the soils that are inside these cracks in the stone, and it's causing the foundation to settle. So that was the issue that we saw, and it clearly is direct result of water being directed towards this property that was normally not there before. I'd like to also go back and speak about these block walls. There's been so much going on the last couple hours talking about these block walls. These are interlocking masonry block walls. They're loose walls. They're made up of individual blocks. They're stuck together. They're not mortared. Therefore, there's gap between each one of these blocks. It is not considered a wall that can retain any water whatsoever. So I'm not sure how Mr. Preddy was indicating that somehow this wall can actually contain water behind it and have it seep slowly, because the intent of these block walls is to allow the water to flow freely through it, so it never builds behind it, because otherwise it creates cytosolic pressures, and these walls are not made for that. So I disagree with the fact that somehow you can have retention pond behind these walls. It just doesn't happen. Not to mention the fact that if the water was to be retained behind the wall, there's so many cracks in these ledge, as I was mentioning before, there are kind of directing water under the wall, because if the water is going to seep through the cracks of the stone, and it's going to find these channels between the stone, and it's going to find its way out. It's just not going to stay there. Not to mention the fact that I believe that the surface is impermeable, and therefore it's not allowing the water to seep in. It's actually just washing over this retaining wall, and it's going directly towards the foundation of the neighboring property. So in my opinion, since this wall and this patio was built, the issue with water towards this 34 foundation has been exacerbated considerably. And I think if it's not stopped, it's going to continue to deteriorate the foundation of 34. That's pretty much in a nutshell what my opinion is. I'd be more than happy to answer any questions.
This is Commissioner Basserman. Help me understand, when you put a foundation on ledge,
yes,
what do you do to bond, if you will, the foundation to the ledge?
Normally, the foundation, when we built a foundation, we always drill pins and rebars, and we grout rebars into the ledge, and then we built the wall on top of the ledge from that point on. The reason being is that ledge is uneven, and the surface many times is sloping. And when you have a situation where there's a sloping surface with the weight, the bottom of the wall will be unstable if it's not pinned to keep so that you keep it from sliding off.
Then is there nothing between the poured foundation and the ledge to deviate any water that might infiltrate to the wall? Or is it strictly the rebar that holds it in place, and the weight of the wall and the house, obviously, that creates a tight seal?
Well, you're never going to be able to create a tight seal unless you have an extremely solid, uniform ledge. Right. As I was mentioning before, ledge will have features in it. There will cracks in it. So you're never going to be able to prevent, water from flowing under the wall. The intent is to keep the wall stable, so that if water does flow under it, it doesn't compromise.
Got it. Thank you.
And just for clarification, Mr. Ashatino, when we were talking about the wall in that explanation you just gave, were you talking about the retaining wall or the foundation wall of 34?
Foundation.
Well, actually, the issue applies to either one of them.
Okay. And could you explain, with regard to the application that's before the commission for the wall that was constructed and that will be altered, or is proposed to be altered, could you comment on the adequacy of the plans and the design and the information that has been provided to assure the commission that the wall doesn't pose a collapse and sedimentation problem?
Well, I mean, we have no ideas what was built. I mean, unfortunately, it looks like they did put concrete, on ledge before they started the wall. But was that concrete pinned to the ledge? If the concrete footing was properly pinned to the ledge, so preventing it from sliding down, the sloping surface of the stone, then, you can make an argument that the wall will be stable. But if there was no pinning of that concrete to the ledge, as soon as you have, hydrostatic pressures behind the wall, or even erosion of the surface by having water sipping through the concrete and the top of the ledge, eventually those surfaces will not be stable, and the bottom of that wall can slide down the hill very easily.
And have you seen any information that was presented this evening that would give you the kind of information that would tell you that stability exists?
Well, no, because obviously this application was presented after the wall was built, so I'm not sure that anybody has any information that indicates how that wall was built. It's all based on assumptions. Nobody has taken the wall down and done some inspections and seeing how it was built. So we really have no idea how it was built. I'm not making a case that I'm not saying that it wasn't pinned, but there's no evidence to indicate that was the case.
Thank you, sir. And so with that, unless there are additional questions for any one of the panel, I just wanted to mention from our perspective that there's two files, the enforcement matter and then there's the application, and they're actually really one combined matter. All of the materials in both files should be unified, because the only reason why you have the application is because you have the enforcement. And so I would like to request that the two files be considered as one, even though you assign them with different numbers, just for administrative purposes. Yeah, I don't want there to be some evidence in one file, not in the other, just for neatness' sake. And then finally, we did receive the plans for this alternative this morning, and I don't think that we've had adequate time to really analyze that. And I think one of my panel mentioned that. And that itself is a reason at least to hold the hearing open until that can be reviewed properly. But that's all I wanted to say for now. Thank you.
Thank you. Any commissioner have any further comments for those representing 34 Howard? I see a hand raised. Let's see. I don't know who was first. Let's see, Mr. Keefe.
Wait, Jamie Frederick and the Wetland agent. I'm not sure who you're responding to, but I had told one person already they were next on the list. But also we have the hands raised for the clients of the attorney that was just talking, so that might.
Right. I thought the person that had their hand raised previously was a member of the public.
So I believe Lisa, I cannot remember her last name because it's not in her name on her. She also had her hand raised and is also an intervener.
Licio.
Oh, she is. Okay.
Last name.
Hi, I'm Lisa Licio.
Yep.
And I reside at 26 Howard Avenue, which is on the corridor in the same road as the two parties involved. The brook, which you guys have seen before, I know the commission's been out and had seen where the brook travels along underneath my property. And in 2002, I did go back and investigate when I personally had a problem with the water that was coming from the drain from Rustic Road underneath. It wasn't piped in at that time. And the water was powerful enough to fill my basement, almost 4 feet high. So the town did put at the end of my property where the bank is, where you see the actual brook, they did put a holding tank there. But the brook does rise, and there has been a difference in the water. And the reason why it is such a concern to me is because the whole entire brook is my right of way alongside of it. And I have had that brook throughout my lifetime in either part of my property or family's properties. So I think that I have seen the course of action that this brook can take. And so any, activity that would affect the brook does affect my right of way as well. So, you know, I do want to say also, and I have been on all the meetings, and I do appreciate the professionalism of the commission. And I do want to say that as a neighbor, I really would like to see both of these parties remediate this problem in some sort of, you know, commonality, so that they can come to an agreement that suits both parties. And, you know, the back and forth and other issues that are involved, you know, just holds this whole process up. And it's been going on since April of 2023. And so, you know, the wetlands is, you know, definitely a consideration, and how the water is flowing. One of the questions that I have as a neighbor is, and a concern, is how close the wall is to the property line. And I think that one of the things that we're not speaking to is how that does affect where the water is running in between the two houses. And, you know, that's one of the main concerns, which in turn falls off the embankment onto the river or the brook. But I do appreciate the Wetlands Commission, and I am hoping that there'll be a quick resolve to this. And caring from both parties and both homeowners, I think, can behoove everybody involved.
Thank you. Do we have any other intervener that hasn't had an opportunity to speak this evening? Mr. Romero? You go ahead.
Hi, everybody. Can you hear me?
Yes.
I'll lower my hand. First of all, we're very grateful to have the opportunity to speak with you all today, because much has been said about us and our property as well. And I didn't know I could feel so many emotions at a Wetlands Commission at 9:30, but I do. You know, our consent has been called unattainable. And I just also want to say, like, we've been here the whole time, you know, like we have come to every single meeting. We've come to 12 meetings. We've come to the site visit. We've petitioned for 2 public hearings because we want to be involved. We want to help find a resolution for this. And I think that it would be helpful to also, you know, clarify some of the misconceptions and potential things that have been said about like our property and, you know, our consent as well, so that we can kind of find a way forward here. And just for background, you know, Steve and I are a couple who recently moved into the neighborhood. We bought a little beach house that needed renovation, and we moved out of we lived in the house for 10 months with no heat actually, and then moved out of it to rebuild it. And when we weren't in the home is when the construction took place for the retaining wall. When we moved in here, it was super important to us to have good relationships with our neighbors. I mean, we threw a housewarming party. We were so excited to have neighbors because this was our first home, and that included Charlie and Kim. And we didn't need a variance for our property. We got all of our permits, but we still shared the plans with for our property with them and asked for input because we want to be good neighbors. It's important to us. And you know, we told our neighbors also when we were leaving the house and when our move-in date was. So they were aware that we weren't in the house when the retaining wall was being constructed. When we weren't there, we knew some activity was going on. We did not know that a 6-foot tall retaining wall was being built at the time. And we also didn't know that it was illegal. Because it was so close to our house, and also because, you know, our neighbors are a U.S. attorney and police officer, we assumed that it was completely permitted. We had no idea that it wasn't permitted, or that they didn't have wetlands permits either, because I mean, we got our wetlands permits and our property was inspected twice by Jamie. The only concern that we had at the time was that it was built very close to our home, and if they had put a fence up in front of the window, we wouldn't get sunlight. And so we had asked for them about whether or not they would put a fence up. We found out that they were going to put a solid fence up on the window, and we offered to pay for the fence if they would put gaps in the window slats so we could get sunlight. That was not going to be possible, that there was no negotiation in that, and that they needed full privacy from us. We then went to the town to ask about fence regulations, and that's when we found out that the whole wall was illegal. We weren't asking about the retaining wall. We were just asking about how tall can a fence be. And that's when we found out that the town, the zoning enforcement officer, told us that they had already spoke with the neighbors and that it couldn't be built without a variance. We were completely shocked. We did not report this. We weren't even sure if we wanted to report it because we didn't want to damage the relationship with them, and we wanted to talk with them at the time. But before we could decide what to do, the zoning enforcement officer came, Jane and John, and they took pictures of their wall. And when we spoke with them, that's when they told us, Jane personally spoke with them, met with them in October of 2022, and told them that they needed both a zoning variance and wetlands permits to do what they did, and handed them a copy of the zoning handbook. They told us they couldn't ignore the violation because it was pretty clear that there was one, even if we didn't report it. And, we were really disappointed to hear that, something was built so close to our house without any permits. And also we could have provided input because there should have been a variance, and that was taken away from us. We got involved with this wetlands proceeding because we felt like we had to. We got then very concerned that this unpermitted wall that also did not have its wetlands permits was so close to our home, which is also in an upland review area. And then we started to learn things very piecemeal over the summer of 2023. So, they also park cars on the retaining wall. And so we got really scared that, typically, because we found out it wasn't structurally engineered, we were concerned that it might not be able to hold the weight of the cars and that it could collapse into the brook. And so we honestly felt like we had to get involved. And that's why you've been seeing us at every single meeting. We were honestly concerned that there was a flood risk, not only to our house, because there's no mortar between the blocks on our side, but also to the brook, and that if it collapsed, it would really be catastrophic for the brook. And we also know, that the brook has affected people's homes before. It overflows. It has flooded people's homes, as you've heard. And that's why we felt like this was a community issue that, we needed to figure out what was going on. So we came to these meetings and we were hoping for resolution. We came to every single meeting, and we wanted to resolve this, but unfortunately we felt like stonewalled into honestly, like we didn't feel like we were able to provide consent because we didn't feel like we had the information needed to make a decision. First of all, our neighbors don't speak to us outside of these meetings. And that's why we always come, because we don't hear about the plans or anything like that unless we come. And this has been, the pattern since the beginning. I mean, in June, they submitted an application to you all for a permit to legalize the wall in its entirety. At that time, we didn't know it was on our property. They had actually gotten a survey that's dated in June showing that it was on our property. And this commission asked them if it was on our property by email in July. They did not respond, but during the August meeting, Jim Perito finally confirmed that it was encroaching. And when he was asked if we had been notified, he said that because we were interveners, they did not need to notify us. He also said that when Mr. Dunn built the wall, he did not have the benefit of a final survey line. But as you heard from their engineers, they surveyed the other property line, but they didn't survey ours at the time. And they chose not to survey our side, even though they built the wall on our side. And they did not notify us that it was on our side. We heard about that during a public meeting. It made us feel very, not involved, that, a neighbor wouldn't pick up the phone and call us and tell us like, look, this is on your property. What can we do to make this right? Since we found out that, this is how we were going to find things out, and also, they weren't in compliance with zoning codes, the plans kept changing. And the plans have changed even today. There's been 4 different plans of this retaining wall. And each time, our consent is called unattainable, but they didn't try to obtain our consent. They don't discuss any of these changes with us. We don't see the plans before they come here. And so it makes it really hard for us to provide consent if we're not told basic things about what's happening on our property. For example, they don't tell us, when do you need to come to on our property? What needs to happen on our property? Is there jackhammering? I know Jim Preddy talked about like chipping the foundation. What is going to happen? Those are things that I think any homeowner would want to know. And I think any homeowner would, and any neighbor would have wanted, their neighbor to come over and tell them like, look, there was an accident here. How do we work on this? That's never happened between the two of us. And on top of that, I mean, we're just also super hurt that during the October meeting, our neighbors asked you to grant them permission to come on our property to do work. Because for whatever reason, they just don't want to work with us. I mean, it's hard to imagine a neighbor asking permission from the government to trespass on your land again, when that's how they built the wall to begin with. And, as time goes on, we've learned more and more about this wall. You've also heard from our engineers. We learned that we learned that there was excavation done to our side. And I know that their side has shared that they did not deny this, but we know that to be true because we know who did it. They had somebody construct the retaining wall, but they had a landscaper come before to denude the forest below the retaining wall. And we just asked him like, hey, did you do this on our property? And he said yes. And that's why we know that they removed the tree stump and the vegetation on our side. Then we found out that there was so much water pouring into the basement that our foundation had eroded and it was undermined and our foundation was at risk of collapsing. We put every dollar that we had into this house, and then we found out that it could collapse. And during that time, we found that out in October. And during that time, the public hearings weren't held. Our neighbors were requesting extensions of you repeatedly, and they were also misrepresenting some of the conversations we were having with them. In November, we told them that we could not consent to the application in its current form. Not that we would never consent, but that given what we had, we didn't have enough information to consent. They stopped replying, and unbeknownst to us, they then asked you for further continuance of this matter because we were in, quote, good faith negotiations. But they hadn't replied to us in weeks. They also didn't notify or check with us about that. And then the extension was granted. Meanwhile, we were told that our foundation was going to fail and that our first floor may drop. And to this day, I still check every morning underneath the dining table that we're sitting now to see if the foundation and the floor is going to drop a little bit. And our contractor, who is on this call as well, he told us that because the fix to our foundation requires pouring concrete and spraying gunite potentially, they can't guarantee the work unless the retaining wall is removed because they're concerned that jackhammering so close to our foundation could crack the new wall. We're scared for the integrity of our home, and we weren't sure that we could trust our neighbors to resolve this issue without the legal system. And this has been an entire nightmare for us. This was completely avoidable, and I agree with Commissioner Gonkowski. He said that this could have been avoided with a call. I think it could have been avoided with 2 calls, one to the town and also one to us. And I know that, again, it's been called that our consent is unattainable, but I think it was just rendered unnecessary and inconvenient. We've been treated like we're the problem, and we've been given little to no opportunity to share our concerns. We're scared even to work on our home because we're scared that it's going to be turned against us. We installed gutters in our house on December 29th, and even after installing the gutters, our basement's still flooding. And we have asked 3 times for our engineers to meet with theirs to have a discussion. We've also offered to go to mediation. Like, there's nothing more that I want to do than to fix this. And this is not how we thought we were going to start our time in Branford. We came here with a lot of dreams. We thought we were going to start our family here, and I don't feel safe in my home. Okay, so getting back to the matters at hand before this committee, I know Attorney Shansky, she also pointed out that, what's under the purview of this Wetlands Committee is that it's determine if this wall will cause impacts. They have only stated that it did not cause impacts in the past, not that it will not in the future. And that's the part that we're really worried about. Despite everything they've shown you, they don't have a structural engineer signing off on the wall. It did not get inspected. It's not up to code still, because if it's draining on our property, which we can literally see, I can see the water coming through the foundation, between the foundation and the blocks. If that's true, then it's not up to zoning code, because zoning code says that you cannot drain water onto another person's property. The brook floods and has caused real damage to people's homes. There's no other man-made feature along this brook except for this retaining wall, and it's gigantic. If it isn't built properly or it isn't draining properly, it will collapse into the brook and also onto our property, which is an upland review area. I'm not anti-wall, I'm not anti-38 Howard, and I'm not here to say that it cannot be built properly. And we would be willing to have a discussion to resolve this if they are. We're just trying to live in this home in a new neighborhood that we have literally built ourselves, which is 27 inches from this retaining wall. And I just want to make sure that if my children are here, they're safe. If you are not certain that it's not going to collapse, then please just have them remove it. I know a lot of people get concerned about costs here, right? And get reticent about that, but they've had 4 lawyers who cost more in legal fees than it would cost to remove the wall. After it's removed, they can apply for permits to rebuild it safely, and they don't have to involve us in it. If you're too uncomfortable with that, then just please wait for the judge to decide next month. And please don't issue us a cease and correct when we want to help here. We have waited almost 10 months for a resolution, and our court date is just one wetlands meeting away. Please just let us have our day to be fairly heard. Thank you.
Thank you for those comments, and I certainly admire the courage to air all that with the commission. I do see Matt Davison's hand raised. Is this in response to something that's been brought up, Mr. Davison?
That's correct. I was hoping you wouldn't choose me to go next.
It seemed appropriate.
You
Go
had
ahead.
to do it. I'm going to bring it back to wetlands, and I sympathize with the adjacent property owner, but I want to bring it back to wetlands. Just a couple quick responses to Bob Russo. One, Bob mentioned thermal impacts, and he made a very important clarifying statement that I'm not sure everyone caught. He said that there would be thermal impacts if the patio discharged directly to the watercourse. Of course, that's not the case here. The patio is draining to a vegetated strip on the backside of the patio, infiltrating down, draining through weep holes. That water then infiltrates into groundwater, drains down that slope. This probably occurs over the course of days. There are no thermal impacts that will occur from that patio to the watercourse. I think it's important to understand scale. The patio is tiny. I've never seen a dedicated stormwater treatment structure for a patio of this size. I would not think it would be appropriate. And to Jim Preddy's point, this patio with the backfill now already treats the water quality volume. There's been assertions that the water is just sheet flowing off of this patio onto the slope and then down into the watercourse. The reason that everyone's been so focused on erosion is because if you had any surface water runoff from this patio to that slope, you would have erosion because of the severity of the slope. There has been none. That is because the wall is holding the water. The water that drains off the walls drains through a very densely vegetated strip before it ever enters the watercourse. There are thermal impacts from the watercourse from Rustic Road, and that would also explain the flashiness that the other residents are seeing. A large portion of Rustic Road drains right into catch basins and right into the watercourse from above. Those present thermal impacts, clearly. There are no thermal impacts from our property. Bob also mentioned NEMO and the landscape scale model for impervious cover. That was not intended to be used for patios. I can assure you that on a landscape scale, that patio is not moving the needle for impervious cover on a landscape scale. And then just finally, I thought some of this was interesting in that a large portion of the presentation dealt with the fact that the water's infiltrating into the patio and then down the bottom and into the neighbor's basement. But then, and I would agree with Bob that I think that patio is effectively impervious. I think that it's draining down towards the back of the patio into that vegetated strip and then out of the weep holes into the back. That just wanted to make those comments.
Okay. I'm not sure who was up next with the hand, but I think Mr. Keefe, why don't you proceed?
Thank you, Commissioner. Thank you, everybody. I just had a clarifying question about 2 hours ago, a couple of comments were made about a reinterpretation of the ordinance in terms of a remediation of lowering the fence from 6 feet to 3 feet. And I know Mr. Aniskovic is here. I'm not familiar with that reinterpretation. If we could just have clarity on that part.
I have absolutely no idea what you're talking about.
Jamie Frederick, and the wetland agent. I think the interpretation you're referring to pertains to planning and zoning and does not pertain to the Inland Wetlands and Watercourses Agency's jurisdiction. So that would be a question for the planning and zoning department if you wanted more.
Although it does have an impact because this application is being, the alternative is being proposed as allowable because of that interpretation, even though you can't change a regulation by interpretation. The straight language, and Bill and Aniskovic and I talked about this, that you cannot change that regulation by interpreting it. The straight language of that regulation is that a retaining wall needs to be set back, the height of the retaining wall, and it doesn't say it, not if it's 3 feet or less. And so that's a problematic interpretation that does impact the jurisdiction of this agency.
So, Keith, Bill Aniskovic from Brenner Saltzman. Attorney Ainsworth is right. If Mr. Keith, if you were talking about Attorney Shansky's comment about the fact that Branford has historically interpreted its zoning regulations to say that a wall lower than 3 feet is not a structure, that's less a reinterpretation than a standing interpretation that has been the subject of some discussion over the years. So it's not anything that's recently happened. I mean, in my time, in my 11 years now as town council, it's always been the case that the the ZEO has interpreted the regulation to be that a wall lower than 3 feet is not a structure. Again, I think Attorney Ainsworth is correct. If you read the regulation literally, there's a good argument that's not a proper interpretation, but that has been the standing interpretation of the commission, of the zoning commission, for as long as I've been around.
Thank you for the clarification.
Mr. Basserman, Mr. Banson, you had your hand up, I think sometime now.
I live on 40 Brockets Point Road. I'm concerned with just protection of residents in general. I don't see that. I know the people at 34, so I don't see that they actually did anything wrong in terms of actually building something that was non-permitted. In terms of specific wetlands risk, we've been talking about the wall falling down. What if 34 falls down? I mean, we haven't talked about the fact that their foundation is getting eroded. If they don't fix it and they just let it fall, what if 34 falls? Whose responsibility is that? If it falls into the brook. I mean, that's actually I'm not an engineer, but if that's a possibility, I think that's, other than my friend's house falling down, that's also a wetlands concern. I'm also concerned about fairness. They built it without permits. We don't know, as people have said, we don't know what's there. And they won't even testify as to why they didn't get the permits. So they're just trying to, it feels like they're trying to like split like wetlands and zoning and just make it all legalese. So they can get away with doing something that, if someone built a retaining wall on my thing and had water going into my basement and destroy my foundation, I don't know what I'd do. And then if I didn't have recourse to have anyone protect me as a, tax-paying resident, I would be very, very troubled. So just to summarize, I do think, if 34 collapses, maybe that's a wetlands issue. If the wall collapses, that might be wetlands issue other than the, just the water flowing. And then it just doesn't seem, who's protecting the taxpayers from structures that damage our property. That's it.
Good night.
Try to.
Peter, you still there?
Did we lose the chair?
Dead silent.
I can jump in if need be for a minute.
Yeah, why don't we do that? Katie, if you could just note for the
He's
record.
back. He's back.
Oh, never mind.
I'm back. We got a bunch of hands raised. Let's see, Ms. Moore.
Thank you. Hi, Maureen Moore. Yeah, I have a bunch of questions, but I won't bring those up. I'm going to go back to Commissioner David's, and I'm sorry, David, please forgive me. I didn't write your name down, but it said David iPad. I know that's not your last name, but his question, general question, why weren't all of the permits gathered beforehand? It seems to me that a lot of all of this would have been done away with if they had done that. I know that this commission works very hard and appreciate them so much, doesn't have to say, oh, we're not going to give it to you because it's after the fact, but with so many questions before us structurally, health, safety, I think it needs to be delved in and researched much more. We're getting one side saying one thing, another side saying another thing. I became aware of this issue through an article in the Shoreline Times. And having seen a retaining wall collapse in my lifetime, I drove over to look at it, and I was just dumbfounded at how massive it was and how close to number 34 it was. It was terrifying. It was overwhelming. Water, if you've ever had water in your home, you know that the probability, of black mold is ever present. That is a safety and health issue that is so massive. If any of you, I hope everyone from the commission has had the opportunity to go over to both properties to look at it, just to put yourself in their place and say, hey, would I be happy with this? Would I be a little nervous about this?
Yeah.
I think we would all agree.
Very well, but
Thank you. Thank you.
you can't.
Hope she didn't trespass.
I was on the road. And there's a bit of disrespect that I'm not appreciating from this commission, very unbecoming to leaders.
Does that conclude your remarks, Ms. Moore?
Yes, sir. Thank you.
Thank you. Commissioner Garkowski, your hand is raised?
Yes, Commissioner, can you hear me?
Yes.
Okay. If we can go back to photos under 10C that Mr. Peretti posted, and go to page 4, I believe, where it shows the patio sloping driveway. There we go, right there. Again, our purview is the inland wetlands, not this stone wall or anything. But this wall has I believe it's going to have a direct impact on the wetlands, because if you look at the picture of this driveway, you can see it's sloping down towards the property of 34, and that runoff is going to run down to the wetlands. So that runoff from that property is going to go directly into the wetlands. I just too many questions here, and that's all I have right now. That's just look at that picture. You can see the sloping towards how it's coming down.
Okay. Back to the, let's see. Is it Kay Walsh? I see your hand raised.
It is. Can you hear me well enough?
Certainly.
First of all, good evening. I'm attorney Kevin Walsh, and I want to just first say that I don't attend actually many of these hearings, and the fact that you all do this every Thursday to volunteer your time is remarkable, and certainly I appreciate it, and appreciate all your time tonight. And I don't want to drag this out any longer with any unnecessary comments, but I did touch base earlier today with Ms. Frederick, and I had asked her if she would, in an effort to kind of expedite my comments, if she might consider pulling up a couple of videos for me. And if I can ask Ms. Frederick to do that right now with respect to, it would be if we could go to Exhibit 10A, which is a 6-second video.
It is Chairman Bassman. Are you representing anybody, Attorney Walsh, or are you in this yourself?
Oh, no, I do represent, yeah, again, this is Kevin Walsh my firm is Williams, Walsh & O'Connor, and I do represent Kim and Charlie. But I want to be clear that I only represent them in connection with a civil case. I've not filed an appearance in this matter. I know that comments have been made with respect to the civil case, so I just thought it'd be fair if I could just make a couple of quick observations, if I might be so permitted. If the commission was decide that it's not necessary or unnecessary, that I ought not, then I don't want to drag it out. But I thought there were just a couple of quick points.
Are we dealing with wetland issues here?
We are actually doing specifically with wetland issues. That was the focus. And that's why I'm directing my attention straight away to Exhibit 10A, which is a 6-second video, a 20-second video. And if I could ask Ms. Frederick to pause the video at about, well, the first 6 seconds, we'll see. Is that possible?
Jamie Frederick in the Wetland Agent. So what, you want it at the beginning or 6 seconds in?
Yeah, if you can play it from the beginning,
okay.
And then we'll stop at 6 seconds. And just to set this up, this shows the water coming off the front of the Norrie home without gutters, which is around the time I believe that they hired a structural engineer.
Is everyone seeing the video?
Yes. Yes.
Okay.
So right there you can see. So this is the water shedding off the front of the house directly at the foundation. And if you, we are, I don't know what, if we're at 5, so go one more second if you could please, Ms. Frederick. And there's the water pouring off the house. So this is the condition before they put gutters and leaders in the house, which I believe is the reason that they actually hired a structural engineer to begin with, because they're having water issues with respect to the basement. But now to tie this into the wetland issue, if I could have now, if you can let that go another 2 seconds. So we get back down to the air conditioning unit. It'll keep going. Yep. You can let it run. And then we see that there is the air conditioning unit right there. Okay, thank you. And that's fine. And then we see behind the air conditioning unit, there's that area. All right. And now, if I can ask Ms. Frederick to pull up Exhibit 10B as in boy. And if you would go to 30 seconds on that video, it's 0.30. The video itself is just over 2 minutes. Right there is actually it. Yep. So right there, you can see that. Oh, nope, you had it right there. That's good right there. You can stop that right there. Thank you. So at this point, you can see the wall was already built, but there's been added work done, which brings the water from the front of that house through that weep hole, which is beneath the air conditioner, down the side of the house. All right. Now, that was not constructed by us, obviously. And if you could now go to 116, that is 1:16 on that same video, you can see that there's concrete that's been added, area that's been added, and there's that weep hole that shows that there's been water emanating from that area going down the side of the house. Now, I should just note that at this particular point, all this has been going on since, well, coming up on almost a year. There is not a single photograph. There's not a single video which shows any water coming through the wall, coming off the back of the wall, coming over the top of the wall. It's not there. And what I just need to be clear is a comment made by the engineers that the driveway the patio area we're talking about doesn't have stone going right to the back of the property. As has been explained by the engineers, there's actually an area for planting that is at the back of the property. It's not depicted in these photographs. So if anyone has the impression that water is going off the top of this patio over the back wall, I think that all of the information is that there has been no evidence. There's no documentary evidence. There's no photograph. There's no videotape of evidence of an impact with respect to the wetlands, which is, I think, the focus of this particular exercise. There has to be some kind of demonstrated impact. And the soil scientist, which would be the discipline involved here, there are 3 soil scientists, 2 that have been hired on behalf of my clients, 1 on behalf of the Norries, who all have said that they do not find that there exists an impact to the wetlands. Now, whether that particular weep hole and drain that comes down alongside the Norris house, we can't explain that. That's not us. That's not our drain there. That's not water coming, as you can see from the wall. And indeed, there's not a photograph. There's no videotape. There is no photographic or documentary evidence, despite having what I understand to be an extraordinarily wet year. I think there was some testimony about it being 133% over normal rain that we've endured over 2023, that there is not a single, and we've had walkthroughs, we've had all kinds of engineers, folks, this is a very tight area. If someone had a photograph or a videotape showing water coming on the side of the property where the Norries are, or off the back that was causing erosion, we'd have it. So I would just ask the commission, and I have the greatest respect for all of you. You dedicate your time and energy to this. The question is whether or not there's an impact. And I understand that there's been lots of concern, but there's been absolutely no evidence that there is any impact. And this condition has existed. And there, like, as I said, there's nary a scintilla of evidence of an impact, even by the soil scientist retained on behalf of Norrie, who acknowledges that, again, he has no information that there is an impact to the wetland based upon his own inspection. So I would just close by saying that grateful of all your time. This is not a situation anyone wants. This is going to resolve. It's going, the issues between our clients. I wish that I had the opportunity to share with you all the discussions, and if Council Representative Norris gives me permission to share with you the demands that have been made upon us, I'm happy to do that. Suffice to say, I'm sure that Mr. Ainsworth is not going to permit me to tell you what they've actually been asking for from us, because he construes that as information made in furtherance of settlement discussions. Suffice to say, I would be happy to tell you all the demands and discussions that have taken place on their part, but it's not being permitted. So anyway, I thank you very much for your time, and again, appreciate your consideration.
Thank you. Commissioner Papatonis, your hand is raised.
Yeah, I have a couple questions based on what Mr. Banson said and what Dr. Norrie said. And I think my question is to Mr. Assertino, but it might be to Mr. Sorikson. I'm not sure. Where, when you looked at the foundation of the house, what portion of it was there a stability problem from the water? Do you understand my question? I don't know if they're still on the call.
That would be for Mr. Ashatino, or Mr. Sampson.
I can answer that. May I go? Yep.
Please.
Yes. The damage is mostly to the portion of the house along the retaining wall, specifically towards the rear of the house.
Is that toward the wetlands?
Towards the wetlands, yeah. So if you're looking towards the wetlands, it's and you're standing on the patio, it will be it's the portion where the closest the retaining wall is closest to the house.
All right. So in follow up to that, again, Commissioner Papantonis. So and in terms of the integrity of the foundation at that point, how stable is it?
There has been settlements and there's cracks in the wall as a result of the corner of the house settling, which is basically an indication that the soils under it have been eroding and the foundation is being undermined.
All right. And follow up, and then if the foundation were to continue to be undermined, what happens to the house vis-a-vis the wetlands? I mean, does it?
Well, eventually, if there is a collapse, then everything is going to wash down to the wetlands.
Okay, thank you. You've answered my question.
Yep.
Let's see, Ms. Molterno.
Thank you. I've been waiting so long to speak.
Yes, you have.
44 Howard Avenue from the first public meeting. I feel like Rip Van Winkle. I don't understand why this is still an issue. My first comments were going to be how disappointed I was in Stephen Sophia for creating this farce and misrepresenting this as a concern for the wetlands. Now I'm beyond disappointed, on to disgust, not only for Stephen Sophia, but for those neighbors that continue to support this guise. They assisted in getting signatures for this second meeting for concern for wetlands, when we all know this isn't about wetlands. It isn't. This committee should look into instituting fines for bringing a false hearing under false pretense. Please ask yourself why this mistake was newsworthy enough for the New Haven Register to run 2 front-page stories. Ask yourself what is really going on here. How can these 2 young people be so vindictive? How can a handful of neighbors support them? Steve and Sophia are so concerned for the wetlands, yet they did nothing for almost a year to alleviate the water pouring off their roof. No gutters, no foundation plants, no drains. They parked their truck in the front of their house. Any vegetation that was there is torn to shreds, leaving a mud pit which runs down Howard Avenue. It's ironic that he chooses to park this truck in front of a front window when he's so concerned about preserving his view. Why is this that this first person to discredit Charlie and Kim publicly at the first meeting was their architect? Why is it that they've gotten their realtor and their builder to be interveners? How can they get away with falsely tarnishing Charlie and Kim's reputation? Charlie and Kim have been nothing but exemplary neighbors. They keep a meticulously maintained home. They have several right-of-way available to them, but respectfully never even use them. When they have visitors or maintenance trucks, they move their cars so as not to infringe on any of our narrow streets here. These are neighbors that shoveled, and I'm talking to my neighbors now, your driveways, not the committees. Picked up your newspaper, picked up other people's dog poop off your property, let your dog out when you couldn't get home in time, used their limited time off to take their dog to hospice to visit the sick, and ironically enough, didn't report Steve and Sophia for having a loose dog that attacked their leashed dog, not once, but twice. I almost feel sorry for Steve and Sophia that their dream house turned into a problem for them. Had it not been for their dishonest, misplaced, malicious pursuit for kind neighbors.
Fair, please.
Thank you.
That's okay. Thank you. And we have one more, I believe, Ms. Treudel.
And just a quick reminder to try and keep the comments to the jurisdiction of the commission.
Ms. Treudel. Laura. I would say at this point, I don't see any other hands raised. Jamie, is that?
We just got another one. I don't think we ever formally opened it up for public comment. So I think that we should announce that we're in the public comment section of the meeting. So if there's any members from the public that would like to speak, please raise your hand and the chairman will call upon you.
I see a new one.
For an opportunity to speak. So
this is Commissioner Basserman. iPhone 14 looks like last name DeVito. If you would like to speak, now is the time. One more time.
I just want to make one comment on the last person who spoke. It's not about personal issues. It's about the wetlands. And if anyone has to build something, they should get a permit. And that's what this is about. There was never a permit required. Applied for in the beginning. And that seems the biggest issue. And now to fix it. And I'll hand it to you. And thank you for the good work you do.
Thank you. And it looked like somebody, Ms. Troidel said, how do I speak? You're
it looks
unmuted.
like you might not have a, it looks like you might, because I can't ask you to unmute. It looks like you don't have a microphone. So since you don't have a microphone, if you want to type your comment into the chat, we can read it into the record for you.
Okay.
I'm
unmuted right now. Can you hear me?
Wait, is this Laura?
No.
Okay.
Yeah, we're speaking with Ms. Troidel.
Jamie, I can't raise my hand. Is it possible for me to be allowed to say something?
If the chairman wants to allow that while we're waiting for the
while we're waiting to move this along, hold on. Let's see, we got another one. Go ahead, Mr. Jackson.
Thank you very much. My name is Peter Jackson. I am the architect of this of 34. I was the architect. I just wanted to correct something that Attorney Walsh said. He, in lawyerly fashion, showed that there was a great deal of water coming off the roof of 34 that was causing their own problems. And I'd like to say that that's just absolutely untrue. The water that comes off the roof, and there was a lot of water that came off the roof before gutters were installed, which were supposed to have been installed during construction. But the water that comes off the roof goes toward the street, not toward the wetland. It looked like torrents of water would be coming down the side of the house, but the side of the house is the gable side. It doesn't have water coming off it. That water that comes off the front goes to the street, and the water that comes off the back, both of which now have gutters, goes into the ground, not to the foundation wall. One other little thing that I'd like to point out that is all of this it's very frustrating because all of this is wetland related, and yet it's not wetland related. One of the purposes, I think, of the neighbors' construction is to be able to park their cars farther up the driveway. And there is a zoning ordinance that very clearly states that no car can be parked within 6 feet of a retaining wall. And that would mean that their driveway is actually going to be shorter than the one they have now. And I just thought I'd point that out because everybody's talking about how the height of the retaining walls and how that might be interpreted, but it's very, very clear in that same paragraph about retaining walls, about parking. I'm sorry all this has to take place. I can't imagine the vituperous
I think the connection just
I think we
froze.
lost you. We dropped you. Let's see. Ms. Diadabo?
Yes, hi. I have just one very brief comment. I represent Kim and Charlie in solely the lawsuit, not in here. But I just wanted to simply mention that there's some discussion about whether this should be essentially tabled, and let the Superior Court do its thing. But we had a recent conference, and the court's going to proceed on their own time and is not going to take away the jurisdiction and actually completely recognize the jurisdiction of the Inland Wetland Commission, and specifically stated that to us. So I just didn't want there to be any confusion about the jurisdiction of the commission and the court not taking it away.
Thank you.
No one made that representation.
Okay. Let's see. Last up, I think we have somebody identified as iPad. You got to unmute. Unmute.
He's looking for it.
There we go. I'm unmuted. Am I unmuted?
Yes, you are.
Thank you so much. I'm Sarah Suter. With all due respect, I live at 2 Rustic Road here in the neighborhood. Rustic Road has been mentioned several times tonight. I see this, I'm not even sure what to say at this point, having heard all of the testimony and everything. I am greatly disturbed about the impact of what has happened to Sophia Nori and Steven Diaz Romero's property. Neighbors coming on without permission, without permits. I'm greatly disturbed about what I'm hearing from various people about the impact on the wetlands, how this house could possibly fall, and then what would happen. These are our good friends, and I can't even believe what I'm hearing about how they're. It's just unbelievable. I knew all of these things, but just hearing it in this format, I'm just really hoping that the Inland Wetland Commission is able to act on this, and for everyone's benefit, my property as well, as far as watershed and flooding and all of these issues that have been brought up. It's a huge concern, and so and I think most of what's been said does impact the inland wetlands jurisdiction, and I'm just hoping and praying that this whole matter can be resolved and safely for everybody. Thank you.
All right, thank you. One more time, Ms. Troidel. Ah, there we go. Picture.
Hi, can you hear me?
Yeah, there's a little feedback.
Okay. I'm sorry. I'm trying to get this so we can say this. So I just want to mention that we've lived in Howard Avenue for 27 years, and we've never had an issue with any of our neighbors, and including our new neighbors, Dr. Nori and Stephen Diaz. And we want to support, and we want you to improve this application by Kim and Charlie to rectify the wall at 38 Howard Avenue. We've heard from Criscolo Engineering, expert engineers, as well as soils experts, that there was, and these are the facts, there was no erosion in 2023 when we had 130% increase in the rain. There was no slide erosion. The retaining wall has not affected the wetlands. We heard from 2 PEs from that, and there's been no impact on the wall. We know there's an unfinished basement, and we know there's soil exposed in that basement, that there was a 1-story house on that foundation. They've had their foundation studied. I think we should look at who did that study, what that 60-year-old foundation, the impact of that, the drainage of the water going down the side. We also have a receipt from Tilcon on the soil. We want to see a very quick, like Lisa Licio stated earlier, we'd like to see a resolution of this problem. It's creating unnecessary tension in the neighborhood. We realize that the project happened without a permit. That cannot change. It's unfortunate, but do we want a solution or not? That's what we're here for. We've heard from the experts, and we're hoping from an inland wetland standpoint that we can approve this standpoint and move on to the next situation. That's what we're here for. Thank you for your time. I really appreciate your time, all of you, and let's work together. Thank you.
This is Commissioner Basserman. I don't see anybody else looking to make comment from public interveners or applicant. Am I right on that? At this point, not so fast. Attorney Shansky.
Thank you, Let me turn my video on. Thank you, Mr. Chairman. I just didn't want you to think that I wouldn't comment if given the opportunity.
I never assume that.
But perhaps the chair could tell us where it is that you want to be going next, because we have some choices here. First, I would like to, if I may, continue for a moment.
Yeah, it's 10:23, so let's keep it short.
Continue at length, and one of my suggestions is that perhaps we continue the matter, provide some additional information that has been the topic of some of the questions raised this evening. I do want to, though, preliminarily say, or intermittently say, or say right now, that none of the concerns expressed by the team of experts on behalf of the intervener. First of all, the Licio and Coughlin interventions have not been supported by any evidence whatsoever. They don't make appropriate allegations of the source of unreasonable pollution associated with the proposed activity. So they have not met a burden at all. And I would argue that, or suggest that neither has the next door neighbor, given, based on what has been said this evening. There's been speculation. There has been inflammatory or sort of hyperbolic and frightening sort of effects mentioned, but none of that comprises substantial evidence. None of it is quantifiable. None of it is specific, and they are concerns. And I'm not being callous and disregarding what's been said. We take very seriously what's been said, but from an evidentiary perspective, there has been none. What the evidence this evening has established, not to repeat it, but all of the soil scientists who agree, no impact. And what the specter of possibilities that are not even likely, but just identified, does not constitute evidence. That being said, we'd love to provide some additional information to the commission that may facilitate its deliberations, and it will provide additional time for Mr. Sonicson to study what has been offered, and perhaps for us to make it more specific if we deem that that comment has a validity in a way that's meaningful to the commission. So that, I guess, is what I would say, Mr. Chairman. We'd appreciate the opportunity to continue the hearing and wrap this up in March.
Let's see, at this point, Jamie, is the proper procedure to continue this with a vote, or how does the commission want to proceed here?
So the commission could continue it. Well, if the commission decides to continue the public hearing, the time, date, and location of where it's being continued to should be identified. And I think that, kind of to the point of additional information, if any of the commissioners have specific additional information they want to make sure is addressed, maybe identify that on the record real quick before we make a determination about whether to continue. And I see that we have two commissioners, I think, with hands raised. Ormrod had his hand raised first.
Mr. Ormrod.
Thank you. This is Commissioner Ormrod. Based on what's been discussed and what's on record, I think there is a lack of understanding just how stable this structure is, given its disposition immediately above a wetland watercourse. I've been out there. There's a pretty good slope going downward. I would certainly like to see some more details about how structurally sound this wall is, given that it's given its disposition, and also it just doesn't seem like we have a good understanding of how surface water interacts with the structure. Does it flow through it? Does it flow under it? Does it flow over it? Does it, is there drainage behind it? Where does that drainage go? So I think we need some more, it seems like engineering information about this wall in its current condition, to make any decisions on whether or not it has a potential impact in the future, down the road. Thank you.
Commissioner Papatonis.
Commissioner Papantonis, I agree with Commissioner Ormrod, because there was a point made, I think it was by Mr. Sonicson, but I can't read all my scribble here, regarding whether there was a plan, what the plan was. With this type of application, we would normally see the plan before we would approve the application. And I think that we do need to see the plan because Attorney Shansky talked about speculation, but we are being asked to speculate quite a bit about what is underneath this structure, how it's attached to the ledge, and whether or not there is actually a risk of some type of erosion into the wetland. So I would ask for the plans.
Anybody else, any other commissioner have information that they would like to see as we consider continuing this public hearing?
Jamie Frederick and the wetland agent. A point that was raised earlier in the meeting and that was also kind of touched on in my staff report is regarding the level of detail with the retaining wall. And that perhaps the commission might want some more information there. It's a little bit hard to decipher top of wall, bottom of wall, and what the grading of the corner, if you will, of what the area between where the wall is and where the wall is proposed on the initially submitted site plan, what that would look like once the work is completed, and how the wall would be brought down to that lower grade. And I don't know if the commission wants any sort of like construction narrative or sequence about how the work would be completed.
Commissioner Basserman, I think that was raised as a kind of a fundamental issue. So I would endorse that, as well as, you know, the comments for those parties representing 34 had some strong words, but I think we do need to see some kind of report or evidence or whatever to support the allegations made by representations from 34. And so I think both parties need to bring some additional material to the continued public hearing, if that's the pleasure of the commission. And I guess given the amount of information that needs to get assembled, it would seem to me that the latter March meeting would be appropriate as opposed to the 1 in 2 weeks.
The 28th.
Is that what it is, the 28th?
Jamie Frederick and the wetland agent. That does fall within the time frame that the commission has without requesting an extension, but it is the last day. So if the commission wanted to continue it again after that date, they would need to request an extension from the applicant.
So if you're ready, I would be happy to make a motion to table this until the 28th.
And a second?
Second.
Commissioner Gokowski seconded. All in
Yes,
favor?
we did. Commissioner Gokowski seconded.
Anybody opposed to
Before
that?
you vote, can I just clarify that that's March 28th and that
March
it
28th and our regular Zoom meeting.
Thank you. Starting at 7 o'clock.
Starting at 7 o'clock.
Okay.
This Commissioner Papantonis, I think, I'm not sure, but that may be a difficult day for some people. I think, is the next day Good Friday?
Yes, it is.
Yes.
Yeah. I just want to point that out before we continue this matter to that date.
Well, I mean, the other choice is to do it in 2 weeks, but I don't know, with the additional information that, you know, is being requested, that might be a little tight.
Or do a special meeting, but the commission just voted on that, correct?
I think we did, but
My brain's a little mush.
Hopefully we can get a quorum.
Right. Yeah, I would say it would be foolish to do something too short and not have the information to act and all of that. So let's take the time to prepare and have the meeting on the 28th with those that can attend. Any other comments, Jamie, hearing before we proceed with the agenda?
No.
Do we need to vote on that?
Wait, yeah, I'm Katie, did they vote?
I
They did not. I
anybody
got a
opposed?
second. I got a
Okay,
second.
so it is
for
still
the
up for discussion. So is everyone?
Discussion on the motion.
Is every, do commissioners present feel that they're gonna have an issue with that Thursday? I do see in the comments is Monday, Thursday, and okay, so then if there's no further discussion, not to steal your thunder, Peter.
I'm ready to move on to the next item.
Gotta vote.
This Commissioner Papantonis, they call the question.
All right, Commissioner Goklowski, are we good to go for the 28th of March as a continuation of the public hearing?
I'm fine with that, Commissioner, Chairman Bassman.
Commissioner Meinson,
Commissioner Minton, aye.
Commissioner Omrod,
Commissioner Ormrod, aye.
Commissioner Boda,
Commissioner Boda, aye.
Commissioner Papatonis,
Commissioner Papantonis, aye.
Commissioner Basserman, aye. Can we quickly deal with the NOV?
This is Commissioner Boda. I would like to make a motion to table 3A and 3B.
Commissioner Papantonis, second.
Commissioner Minton, I second that.
Is there any further discussion? Want to take a vote? Commissioner Omrod,
Commissioner Ormrod, aye.
Commissioner Papatonis,
Commissioner Papantonis, aye.
Commissioner Goklowski,
Commissioner Goklowski, aye.
Commissioner Meinson,
Commissioner Minton, aye.
Commissioner Boda,
Commissioner Boda, aye.
Commissioner Basserman, aye. Thank you for hanging in until 10:35. Enjoy the weekend, guys. Meeting is now closed.
No.
Oh,
There's
one more item and they are present, so.
Short drive?
And Mr. Chairman, I don't believe you need me for the next item, so permission to go to bed?
Yeah, sure.
Yeah.
Yep.
Thank you.
Anybody else not needing for the next item? Enjoy your night. What's left of it. All right, is that the only item that we're here to consider now?
So we've got one item left. Applications for review, IW 240201 380 Shore Drive, 1-story art studio with support spaces and breakfast nook. So we do have a representative for the applicant present. I will hand it over to them because I'm sure they'll be able to do a much more concise, focused, and detailed presentation than I can lead in with. However, if they want me to screen share anything from the application materials, I can do that.
Thank you, Jamie. Can everybody hear me?
Yes.
Yes. Okay. Just for the record, my name is Matthew Bruton. I'm an engineer from DL Companies, headquartered at 355 Research Parkway in Meriden. And that one was a doozy ahead of me. So I enjoyed listening, and I'm happy to be not part of either side of the application. But Jamie, do I have permission to share? I can run through this application, which hopefully will be short and
Yes,
sweet.
as long as you're sharing things that have been submitted.
Yes, I believe I have. Yep.
If not, I'll let you know.
Okay. Okay. Sounds good. Okay. So I'm here on behalf of the applicant for 380 Shore Drive. I'll just for the record, Amy, you can tell me if I'm out of line with this, but this is the house on Shore Drive, just from Google Earth aerial, single family residence in the R4 residential zone, a little over or a little under a 0.45 half-acre lot.
If you can just screenshot that and send it to me, that would be great.
Absolutely.
After the meeting.
Absolutely. I will do so. Yep. So as you can tell from that aerial and back to this map, this is the existing single family home where my hand is hovering right now with my mouse, with an existing garage and a wood deck. In addition to that, why I'm here is there's also a pond partially on the property, and I will outline the borders of that pond right here. as you can tell, it falls within the property and does outlet out in this direction, which is southwest. What the applicant is looking to do, as Jamie said, is to build an addition to this existing single family home that could double as can be used as an art studio, but also be something that they could be used eventually as a first floor master, potentially if they age in place in the home. So what is shown here on the plan, I'll just highlight just for clarity for everybody. So there is the existing home here. I will trace in green, and then I'll do the proposed addition in orange here. So there's a little addition off the back of the building, also here as well. And then change colors, and in pink here as well, there is a little ramp and deck adjacent to the proposed addition. To make this happen, the goal would be to remove the existing shed here and garage. And this would fall all under, if you can tell from the bottom of the survey here, this would mostly fall within the existing impervious area, which is a crushed stone driveway that kind of snakes around the existing structure. As part of the application, the applicant has provided some architectural plans, which I know is maybe not the purview of the board, but just to give you a sense of what this will look like. Obviously, the existing home is depicted in kind of this lighter color here, and then everything to this side here would be the portions of the addition to the house, and then the deck and ramp area that I circled again on the site plan. So also submitted with the application was an erosion and sedimentation control plan from BO companies. So this depicts a couple of devices that we would like the contractor to install prior to the excavation for the proposed addition, and would like to stay in place until the site is stabilized. The goal obviously would be able to protect the pond, but also adjacent abutters. So you can see on the plan that I've shown here, I'll just zoom in, we show a proposed construction entrance. We show silt fence and straw wattles as a double row of protection adjacent to the pond that does wrap around all three sides of the proposed addition. And we do show a soil stockpile area as well for temporary storage of material that will then obviously be then exported off the site. That is kind of a quick high-level overview of the proposed plan. So I'm happy to answer, I guess, any questions that the commission may have.
This is Commissioner Pope. Which guidelines were you using when considering sediment and erosion controls?
2002 sediment and erosion control guidelines, Connecticut guidelines.
Okay. Have you looked at the 2023 guidelines?
No, not. I can go back and double check those for you, Commissioner.
Thank you.
This is Commissioner Basserman. The plan that is on the screen now, is that part of the A sheet package? What's the nomenclature on the EC1?
This is EC1, Mr. Chairman, erosion and sedimentation control plan.
Jamie, I don't think that was sent out with the.
I think it was. It's kind of buried in all the architecturals.
Sorry, let me see if I can.
Oh, sorry. Yeah, that's an updated wait.
Okay, so that'll get said subsequently.
Yeah, I guess I didn't look too closely at the packets that were put together for the commissioners.
No problem.
You're correct.
Okay.
So I believe it's by and large the same, but the erosion controls were added to the file, which we do have in the Dropbox, and we do have full-size copies of, but the commissioner packets apparently did not get the updated site plan.
Oh yeah, then don't send them out. If it's in the Dropbox, I'll look there. Any other questions from the commission?
This is Commissioner Boda. I think that we could probably actually potentially rule on this in the what's it, the 14th?
Right.
Yeah. Okay. Are there any other questions the commission has for the applicant? I did prepare a staff report, and I'm sorry if I missed responses. I was moving some stuff around on my desk. And two concerns that I had identified were there's no indication on the site plan regarding stormwater management or how stormwater will flow on site. And then there was a little bit of a question regarding the total area of disturbance and whether the application fee was complete.
So, Jamie, I looked at the two questions.
Yeah, both of those can be resolved by the next meeting, no?
Well, okay, so I guess, I mean, I can resolve the application fee question with the applicant. I guess my question for the commission is, do you want to see formal stormwater management, or do you want to see if the applicant has any comments regarding what they're proposing currently?
This is Commissioner Boda. I would always prefer to see stormwater management and the sediment and erosion controls. And I think taking a look at the 2023 guidelines may give you some little push in the right direction.
So Commissioner, I can talk to it a little bit to maybe help you or give me some guidance again. So I'm just gonna drag these squares that you see down onto the plan just so everyone can see the potential impact. So the green areas are areas that are currently impervious, right? So the existing shed, the existing garage, those are currently impervious but would be removed from the site. So these would be becoming landscaped areas again. The areas in orange are currently landscaped areas that would be becoming impervious, right? So you can see here the edge of the driveway here, but the addition is going past it. If you add up all these things, the net increase in impervious area is 30 square feet. So to me, I can put together a memo in relation to that impact related to stormwater, but as you can tell, it would be de minimis, 30 square feet. We could add a stormwater management system to this, but it would really increase the disturbance of existing vegetated landscaped areas on this site. In general, everything, as you can imagine, flows kind of closer to the pond, but I'm happy to add additional information if the commission wishes to see that before the next meeting, but just to give you a sense of
Commissioner
scale.
Boda. I wonder if you might, I mean, I understand that you're going to remove the shed, but then you're going to add, then you're replacing that with the addition. And are you looking at infiltrating the roof runoff, regardless of the net, for that total square footage? Are you looking to infiltrate that roof runoff? Because that would be ideal.
So right now, yeah, understood. Yeah, so we are looking to infiltrate it, but just by allowing the roof water to outlet down to grade, right? Not looking to propose an underground storage system. As you can tell, there's ledge identified above grade on the survey here. We suspect that it's around elsewhere as well. So the goal would be to allow the stormwater from the roof, from the slight increase in impervious area to outlet to grade to the vegetated areas and grass, and be allowed to infiltrate, in sheet flow on the property. Not looking to formally put it underground in a system.
So will it infiltrate if you're on ledge, or it's just going to run off?
Well, it'll infiltrate where it can. Obviously, getting into the vegetated areas, there is some soil in those areas. There's also obviously plants and landscaping that would be able to suck up the stormwater to allow that to be part of the.
So you might consider putting in either some plantings and augmentation with soil to help infiltrate. You might consider a dry well, there's any number of things that you can do to, I think some of the guidance that's coming out is we really want to try to move away from all of that sheet flow. And I know it's a small space, but with wetlands, it's and runoff, we're looking at death by 1,000 cuts. And so I think where we can infiltrate even small amounts, that's really what the state is guiding us to do.
Understood.
Jamie Frederick and the Wetland Agent, just one more topic I want to bring up. I know it's late. There was a question of whether or not they needed to have a formal wetland delineation. I told them probably not, given that it's a pond and there's a fairly steep bank. Just want to see if any of the commissioners have any concerns with me with that guidance. I can I'll just share one picture real quick. So you can see down here is the pond. There's this rather steep drop off shoulder with some vegetation, and this is the driveway that goes around to the back of the building. So based on my observations and notes in the file from the previous wetland officers' observations, it does not appear that there's any fringe wetlands adjacent to the pond. So I don't know that a formal wetland delineation is needed when the survey shows the pond edge.
If this Commissioner voted, I don't think if there's no contest over what is existing, it's
okay.
Okay, so can we table this to the 14th at our regularly scheduled Zoom meeting? That's actually a motion.
I don't know that you need to motion it.
I'm gonna do it
announce
anyway
it
to move things along.
I second that now. I second that motion.
And I think we have a uniform consensus on that one. Anything else, Jamie?
Can you just at least do or against?
What's that? How about thumbs up? Can we do thumbs up?
No, not visual. Any opposed?
Any opposed? Any
No.
abstention?
Okay.
All right.
Okay. All right. Other business, none. Agent approvals, none. We have an aquatic pesticide permit application notification. It's one we've had before. So nothing new there. Given that's all business.
Motion to adjourn?
completed, are you?
Make a motion to adjourn.
Yep.
Second.
Good night.
Night.
Good night.
Good night, everyone.
This program was brought to you in part through the support of the Town of Branford. Watch town meetings and other videos on demand at BranfordTV.org.